For what purpose?
My lord, I have got a award from the telco. Insurance company preferred an appeal. Did not take any steps at the admission stage.
No,
I am
no.
not getting any
Which year appeal?
appeal preferred at 26.
Okay. It will appear under the heading claim case hearing after 2 weeks.
May I permit to mention, my lord, first miscellaneous appeal,
Yes.
2019. My lord, let it be.
Yes. Appeal of what? Claim case?
No, not claim case. It is first miscellaneous appeal in connection with the civil suit. My lord,
Okay. After 2 weeks.
against the order of remand.
Yes. Yes. After 2 weeks it will
May I
appear.
mention for restoration, madam, I'm mentioning for after.
Sub notice.
Yes, madam, sir.
For inclusion in the list, application for stay of title suit for eviction. I
No,
have
no.
mentioned the matter
No. Application in second appeal.
second.
Okay.
Your Lordship, this matter was fixed on 16 July and for hearing by the order dated 30th June. And learned senior advocate Mr. Joint Minister is appearing in this matter. And since then, the matter is not coming in the.
You let it appear under the claim case hearing. Thereafter, I shall fix date. Let it appear under the heading claim case hearing.
My lord, may I be permitted to mention for application under section 5? Kindly list the matter.
Sub notice. No. Give it and thereafter sub notice and copy of the application.
My lord, permit me mention, my lord, regarding item number 97 and 98. This is the MSCC.
Yes, wait. Outside the list first.
In the list, my lord.
Outside the list mentioning first. Yes.
Inclusion of the matter is at 3717 of 2017. Is a hearing state.
Hearing. Yes. After 2 weeks it will appear for hearing.
My lord, may I serve?
Yes. Give the slip.
Not two hearing, Lord.
Hearing. Yes. After 2 weeks. Hearing of claim case.
My lord, for hearing of this application.
Hearing of
Hearing of second appeal.
second appeal. Yes. After 2 weeks.
My lord, for inclusion in the list, the cases of 2014 for it's a civil division.
ঠিক আছে দেখি কি বলে yes just
May I be permitted to mention a matter for the inclusion in the list?
under heading hearing.
Hearing.
Yes, after 2 weeks.
May I permit to mention.
Civil
for
review.
the last question, your lordship direct my lord to send the matter to the Lok Adalat. The disciplinary does not that did not take any decision matter. Thereafter, the matter fixed as a especially my lord before this honorable court.
Anyway, let it appear under the claim case hearing. Thereafter, I shall see. Let it appear under the heading claim case hearing.
Fix the matter as
No. Let it appear. Thereafter, I shall see if I can fix a date. Let it appear under the heading claim case hearing. It is not appearing.
Yes, sir, it is appearing.
It is appearing. Okay, then you wait for some time. Yes. Any other outside the list? Outside list mentioning any other? Yes. Yes. After 2 weeks.
Hearing of claim case, my lord.
Yes. After 2 weeks. Okay. Application will appear hearing after 2 weeks. Application. Yes. Give it.
The civil division application, my lord, you also directed to appear on 6th of July. My lord has heard this matter. The matter is not appearing.
Anyway, give it. It will appear next Monday.
My matter also appear next Monday because the logic is up to date and the matter was in the list, but logic is not. They are not.
No. Matter appeared when? Okay. Let it appear. Let it appear under the claim case hearing. Oh, civil division. Yes, next Monday. Yes.
One matter for application first.
Oh, application. Just wait.
My lord, permit me.
Yes, outside the list. Any? Yes.
My lord, permit me mention regarding item number 97 and 98.
Yes.
This is the MSCC case, my lord.
Okay, upgraded
Madam, one
will not be made now.
One thing, my lord.
You see, I have indicated in the list, please.
Yes, my lord. I
have already indicated.
My lord,
please.
kindly hear my
No,
comment, my lord.
No question of it.
2009 in the accident was claimed. My accident was held.
Many old matters.
My lord, this is my 2016 matter, my lord.
Well, very
My
well.
lord,
There are older.
I do not know, my lord. 23, 24
There are
years,
older
my lord.
matters than that. No, not now, please. I have
My lord,
indicated.
my lord, on the last occasion, your lordship were pleased to, my lord,
Now,
when
I have fixed different matters.
But at any day, my
No,
lord,
no. You just wait for 1 or 2 weeks. Thereafter, I shall see. No upgradation. If it is taken up chronologically, well and good. If it is taken up chronologically, well and good. Otherwise, just wait for some time.
আমি দেখবো তাহলে একদিন ফিক্স করে দেবেন ক্লেম কেস হিয়ারিং
My lord, item number 117 of.
Yes. For what purpose?
My lord, it's a claim case hearing, my lord.
Yes.
It has been appearing for quite some time. The only difficulty and predicament I'm facing is the appellant's counsel will be coming down, external counsel coming down here to argue. My lord, he has already come down before, so he has only
No,
paid it. My lord,
just wait for some time.
as per my lord.
No. If it is taken up chronologically, well and good.
My lord.
Let's wait.
123.
123.
There is application, not my application is there.
123 application.
And
Application for?
application, the hearing.
No. 123 is application.
Hearing. Let it
No. 123 is appearing under the what heading?
hearing, Lord.
So it should come under the heading application. 123. Yes.
That's item number 218, Lordship, only quantum matter, the matter.
No. You just wait. For the time being, please wait.
See, they are bound, my lord.
No. Let it be taken up. You see, let this claim cases matter be called on. Hereafter, I shall see.
At least, weekly 2 times.
There are many matters. You see, there are many old matters. You just wait. Yes. Yes. Give it.
Lord, we have concluded our submissions. Lordship has already heard completely. Your Lordship was pleased to direct us to file the written notes.
Yes.
These written notes.
So you are appealing for the
Petitioner,
you are appealing for the
opposite
private
party number
respondent.
one.
Opposite party number 1.
Lord, corporation is, yes.
Yes.
Filling the written notes to what? With the judgment, my lord.
Now another thing is this. This is was this a case of entire demolition or the only the
No.
That is mentioned, my lord. What are the demolition?
Demolition of the
not the
offending.
entire, or not the
No.
entire,
Offending part, only a cantilever was extended.
only one portion
Only
demolition.
cantilever was extended. That is also under permissible limit.
Mentioned in detail if your lordship go through.
No, I'll go through that.
Yes.
I've heard the matter.
No, not the side open spaces have been enclosed. Yes. But by making construction in every floor, thereby we are extending the floor area ratio. And the over my lord, the 2 floors which the petitioners.
So today I think it is not the matter is.
No, I'm just asking one thing. Whatever there is on the record, not merits of the case.
No,
Is it a
not-
case of
that is-
only
that is-
demolition of a
No.
particular portion?
Only the offending part.
What are the offending portions that have been mentioned?
In the demolition order,
In the demolition order.
only those portions are to be demolished.
So, my lord, the order of the learned tribunal in one paragraph clearly mentioned, and also the violation.
Tribunal has confirmed the order of the special.
Yes, that is why.
It is beyond
That is,
concern, my lord.
that means entire building is not directly to be done.
Only the
Only
offending
the
Offending
portions which have been contravened
Yes.
as per the rules.
This has been converted into the dwelling portion that has been mentioned, my lord, in the order also.
That means some portions of the building.
Not-
Yes, record an order.
Sir.
Learned advocates for the parties are present.
bolo.
The hearing of this matter is concluded. Learned advocates have filed written notes of argument. Let this matter appear on 20th of August 2026 for judgment.
Obliged.
My lord, I am for the petitioner.
Can 2 is whose application?
And to already disposed of.
So you are for the plaintiff petitioner. Let me see the record.
This is my ability to serve.
The opposite party did not enter appearance.
Not enter in any time. I think.
You serve the
Yes,
trial
my
court
lord.
advocate also.
No, trial court advocate? No. Only opposite party.
Item number
10.
10. Hey, 10 নয় তো এটা।
আচ্ছা দাঁড়াও।
এটা 13টা দিলেন। 10 আর 11টা দিন। Is there any interim order existing now?
No. Your lordship dismissed the matter, your lordship restored the.
Let me see the order. There are two divisional applications.
Yes, next matter also. My lord, very short matter, my lord.
This is order dated 6/10/2025.
Joseph.
Page number 40 division. Page number 40. Number.
You are the petitioner in the title suit.
Yes, my lord.
So you have lost before the trial court as well as the appeal court.
Both the court I have lost. My lord, this is a petitioner, my lord, filed an application for preemption. My lord, both the court held that dismissed the application that they are time barred application.
According to
Application was time barred.
the order, the application was time barred.
Yes. My lord, here, my lord, held it executed on 24th July 1991. But the same was actually registered on 3rd October 1996. Dicta.
October 1992.
3rd October 1996. My lord, your lordship, see, the cell.
No, it is in the record.
My lord, exhibited it with me.
Okay, let me see
Babu.
that.
Your
The
answer?
trial court records have come.
No.
So trial court records are to be seen. Both the trial court and the appeal court records. What were the, because you see, unless the trial court records are produced, what evidence was adduced, that cannot be considered.
And a certified copy is there. I have.
So it's better the trial court records be called for. And a notice be given to the advocates of the trial court.
I advocate of
The trial court, no, nobody entered appearance here.
Yes.
So it's better you serve the trial court advocate.
Huh? জানি না বেঁচে না থাকলে চলবে না
Yes, record an order.
I affidavit of service.
Learned advocate for the petitioner is present. Affidavit of service filed be kept with the record. None appears for the opposite parties in spite of service of notice. However, in the interest of justice, the matter stands adjourned till 20th August 2026.
20 August.
Hey, sorry. 17. Okay. 20th August 2026. The trial court records and the appeal court records we call for. The learned yes, by the special messenger cost to be put in within 2 weeks. No, by 2 weeks it will not come.
Within 1 week.
Within 1 week, the learned advocate appearing before the trial court and the appeal court be intimated by the learned advocate for the petitioner.
Yes. Same matter, man.
11, same order,
Same order, my lord, affidavit service.
same order.
কালকেই দিয়ে দাও।
My lord, I am for the petition.
I am appealing with the legal years of opposite party number 1. Opposite party number 2 and 3 possibly not served till date.
My lord, this is my reply.
Oh, this is restoration application.
Restoration application.
You are representing which respondents?
Opposite party number 1.
Opposite party number 1.
Yes.
My lord, in this matter, what happened, my lord, in the opposite party number 1 died, my lord, thereafter, here, my lord, that their heirs has not been substituted.
But in the trial court,
Trial court that has been substituted, but so far my subject
you are
to correction.
representing respondent number, opposite party number 1.
1. Legal years of
That's,
opposite party number
that's
1.
why, my lord, the honorable court directed to file a substitution application after setting aside of order. That is in can 3.
Unless substitution application is disposed, none of the matters can be taken up.
My lord, before that restoration must be otherwise.
See, restoration application is between which parties? Between the, not between the dead, one of the parties which is dead. It has to be between the parties which is alive.
My lord, that is the difficulty. What happened? The the substitution application has been
Or
filed.
for restoration application hearing, you are required to substitute the heirs.
My lord,
Because they are to be brought on the record.
my lord, kindly see the previous order.
What is the substitution application?
My lord, can 3, my lord.
Can 3. Let us take up.
Can 3 of 24.
So question is, during substitution application, pendency of substitution application, the entire matter was
My lord.
dismissed. Anyway, whatever, even if it is to be restored also, the parties are to be brought on the record.
Not a single restoration time of dismissal.
Can 3?
3 times dismissed.
Let us come to the substitution application first. With regard to restoration application, you submit your arguments.
My lord, page 5, paragraph 8, my lord.
Para 8.
Para 8.
Opposite party number 1. But you are representing whom? Heirs of opposite party number 1. Heirs of opposite party number 1. But anyway, let them be substituted.
My lord.
Yes, record an order. Learned advocates for the petitioner and learned advocate representing the heirs of the opposite party number 1 are present. The application for substitution being can 3 of 2024 is taken up for consideration. Our learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocates, that this court is of the view that the application for substitution should be allowed. Thus, this application stands allowed. Let the names of the opposite party number 1 be deleted from the cause title, and the names of the heirs of opposite party number 1, as mentioned in paragraph 8 of the application, be substituted in their place and stead. Stop. As the opposite party number 1, as the heirs of opposite party number 1 is represented, no further notice is required to be served upon the heirs of the opposite party number 1. Let the amendment be carried out within 2 weeks. Let this matter appear for consideration of the restoration application on 17/8/2026.
My lord. My lord, may I file the reply, my lord? The can 4.
The reply to?
Can 4.
The reply to can 4 file be kept with the record.
এই যে এটা একটু নিয়ে নেব।
Yes, it will be taken up after 2 weeks. The other opposite parties are not represented.
No service was made, plus.
No service affected.
No service was made till
Because
date.
they are not the interested party, they are
No, they are at the original
Yeah.
builder.
In the meantime,
Original-
service upon the other opposite parties be affected directly as well as by serving the learned advocates representing them in the trial court. So in the meantime, you serve them.
My lord, I appear for the petition, my lord, in these matters. Mr. Arindam Banerjee was making submissions in this matter. My lord, kindly pass it over, my lord. Mr. Banerjee is on his way, my lord.
You are for?
Petitioner.
Who is for the opposite parties?
Our opposite party, the respondents were represented
pass over.
previous election.
So both the matters 13 and 14.
13.
Yes, for 13, 14 pass over.
Grateful, my lord.
I appear for the opposite part.
My lord, I am for the
Number one.
petitioner. My lord, I have a, my lord, objection with regard to my learned friend appearance. He cannot appear for the OP number 1, my lord.
Let me see.
My lord.
Why?
Yes, yes.
Opposite party number.
I have raised the question, then I have to answer. In a previous round of litigation between the same parties, my learned friend appeared for the other defendant. 272 of things. My lord, Kardin.
The other,
You are, yes, Mr. Ali, you are representing?
the opposite party number 1.
Era my lord, Kardin ota. Well, kindly see the certified copy. In this matter, my lord, I was the petitioner, the MD Selim. OP number 1, the management Hugli Mambaras, and 2 was MD Ali. And Mr. Arif Ali appeared for the opposite party number 2 therein.
Opposite party number 2.
In that certified copy. In that certified copy.
In another matter.
In another matter, connection with the same suit, same property.
You are appearing. Is there any conflict of interest?
This is, I don't know.
Yes,
I
yes.
don't know who was the advocate on record. Our junior.
Yes, Bhattacharya. There is a conflict of interest.
So, last time you appeared for?
Well, in this,
May I take instruction in that case? Tomorrow,
Is there any objection with regard to the said
I
party?
have no objection. Your lordship kindly consider this because they are a conflict of interest. There are conflict of
I have
interest.
to take instruction. If my learned friend says that,
Yes,
I
record
am
and
not
order.
saying that. This is on record.
Learned advocates for the petitioner and learned advocate for
the opposite party number 1, lordship,
opposite party number 1
but I do not find any
are
petition.
present.
So,
It is submitted by learned advocate
better
for the
lordship keep it
petitioner
tomorrow.
that Mr. Ali representing the opposite party number 1 has appeared for another party. That is opposite party number?
My lord,
It's 3 here.
three in the present
Party
proceeding.
number 3. Stop. It is further submitted that the issue involves conflict of interest. Stop. In the event the matter stands adjourned till 17/8/2026 to enable the parties to take.
My lord, next week, my lord.
No, 2 weeks. 17/8/2026 to enable the parties to take necessary instructions.
Yes, your lordship. Well, the copy of the order will be kept with the record.
Is the certified
Yes.
copy of the order passed in
CO 272 of 2023.
কোথায় রাখ গেল এটা?
CO 272 of 2023.
Oh, passed in CO 272 of 2023. File be kept with the record.
Grateful to lordship.
এই যে।
That 16 and 17, I am for the opposite parties, my lord. I am praying for not this week, my lord.
Yes, you are for?
I'm for the petitioner, my lord.
Okay, not this week.
My lord, deeply obliged.
Item number 18, my lord, I appear on behalf of the petitioner, my lord. I'm for the opposite party number 1, my lord. The last
And one, your application.
the last occasion, my lord, your lordship was pleased to direct. My lord, there is a suit for on the ground. A
What is
preemption.
your application? Can one?
Can one, my lord, the application for extension of interim order, my lord, your lordship was pleased to extend the interim order for a limited period, and that is
What is
continued.
this division? Let me see.
My lord, what happened, my lord? A preemption case has been filed on behalf of my client. My lord, who is the preemptive petitioner before your lordship?
You are the plaintiff petitioner.
Yes. My lord,
Okay.
no,
Let me see the order.
No, my lord, I'm the opposite party defendant in a suit for preemption. Well, in that suit, my lord, they claim that they are the co-sharers. They ask for a preemption on the ground of co-sharership and vicinage. Well, now the trial judge decreed the suit holding that he's a co-sharer and he owns adjoining ownership to the land to be preempted. My lord, our specific defense is that he's not a co-sharer, the suit is not maintainable. And in the meantime, my lord, we have taken a point, my lord, this is Bastu land, therefore this is not preemptable. My lord, the matter came up before your lordship for hearing on the last date, my lord. Your lordship was pleased to direct us to submit the orders where your lordship will find that the matter is pending consideration before this honorable court regarding.
So both the cases you lost.
No. In the first case, my lord, the co-sharership has been upheld with the ground of vicinage. The appeal court reversed the finding, holding that this is not a case of the co-sharership has been upheld, and the question of vicinage has been.
So the preemption case was allowed.
Preemption case has been allowed. We have filed this application, my lord. My two defense would be there.
So you are the preemptive.
I am the preemptive, my lord.
You are the purchaser.
I am the purchaser, my lord. What happened, my lord? This is a case, my lord, where I have specifically stated in my application also, my lord, two defenses I have taken, my lord, because when I registered by means of registered deed, a specific portion has been sold to a purchaser, my lord. He doesn't become a co-sharer; he becomes a co-owner.
The trial court records have come. It is necessary to go through the records.
That is the reason, my lord.
Yes, record. Learned advocates for the parties are present. Are learned advocates in the instant matter. The trial court's records are necessary for consideration of the matter. Let the trial court records and the appeal court records be called for. Let this matter appear, call for at the special messenger cost of the appellant to be put in within 1 week. Let this matter appear on 17/8/2026. The interim order 17/8.
17th August will be very short because this has come from Jalpaiguri. This is a Jalpaiguri matter. The lordship can make it first week of September.
Okay. 14/9/2026.
As your lordship. One thing, my lord, your lordship will kindly extend the interim order. The interim order will
Interim order granted earlier stands extended for a period of 6 weeks or till further orders, whichever is earlier.
Till the end of September, kindly make.
It will appear on 14th.
16 to
6 weeks. 6 weeks.
Oh, no, তার শেষ হয়ে যাবে তো 4 সপ্তাহ 14 আগে শেষ হয়ে যাচ্ছে
Okay, 7 weeks.
7 weeks. I'm grateful.
My plaintiff is the petitioner, my lord. We have filed two applications, one application for substitution within time, and another application for expunging the name of opposite party number 1, who died, my lord. At the time of filing the my lord, revisional application, lack of proper instruction, my lord, application has been filed, but before the trial court, they filed an application for substitution, which was allowed by. This is the my lord, information. My lord.
So petitioner number 1 died.
Died within time. We just died. And here, my lord, opposite party number expunging petition.
So, but the case is filed by the petitioner number 1.
Petition number 1.
So, by the dead person.
No. Petition number 1 died, my lord.
Pendency.
During pendency.
During pendency.
And another, my lord, expunging petition. Yes. expunging opposite party number one.
No, petitioner number one died during the pendency of this application.
Petitioner number one died during the pendency of the application. And opposite party number died before, my lord, at the time of filing the application, my lord, due to wrong instruction, my lord,
That is Raj Bihari Jana.
Raj Bihari Jana. Well, I already made an application for information, and my lord.
And this application is for deleting the name of this opposite party number one. And so far the petitioner number one is concerned, these years are substituted or already on record.
No, substitution application within time.
So this can 3.
Can 2 within time. No, no.
Oh, item number ta likhe
Oh, you also got it, the information I have already handed over.
So this is for recording the death of petitioner number one. Okay. That is, in this application, you have prayed for recording the death of petitioner number one, Shankar Jana. And his years be substituted in paragraph 2. This is can 3.
Can 3. Can 3.
And any other application?
Application can 1, my lord. Expunging the name of opposite party one, Raj Bihari Jana. Old number, my lord, 3839.
Yes, এই ইয়েটা দেখি ওই can 3 1টা এর মধ্যে কোথায় আছে পুরনো এটা 7314 old number.
Yes, man. 3839.
3839.
29.
আরেকটা জেরক্স করে দিন দেখা দেবেন ওইটা দিয়ে দিন condition
Page 10, paragraph 2 and 3. In paragraph 20, Raj Bihari Jana died on 10th of February 2016 prior to filing of the revision petition, and it has already been substituted this suit.
In the trial court.
I have already, my lord, filed this.
Therefore, the name of the Raj Bihari Jana is required to be substituted, and the heirs are required to be.
সামনে দেওয়া কৃষ্ণা জানা
The heirs are followed at page 8. They are filed this application. Page 8, manner, on the death of Raj Bihari Jana.
Yes, two application, one for recording the date of petitioner number one, the other is for recording the name of opposite party number one. Yes, record and order. Learned advocates for the petitioner number, the applicants.
So for can 19 matter taken up first?
No, I am taking up this two.
One,
this
of 19. The first application manner,
this is 7314.
Yes. 3839.
No, this one is this Can 3 of 2024. This is for recording the death of the petitioner number 1. And the other is 3839.
All right.
It's a current number ta koto? What is the current number?
Can 1 of 29.
Can 1 of
19.
2019. Learned advocates for the petition applicants. You are representing all the petitioners except one.
Except one, yes, ma'am.
Because if once legal heirs have not filed any of this application.
File this application.
Oh, this application for substitution is filed by the applicants. That is the heirs of this Shankar Jana.
Yes.
The learned advocates for the applicants and learned advocate for the petitioner number 227.
Yes, madam.
Petitioner number 227 and the applicants.
Yes, sir, 227. Petitioners.
And the learned advocate for the opposite parties are present. Hard learned advocates. The applicant, yes, of the petitioner number 1, Shankar Jana, has filed an application for recording the death of Shankar Jana.
You died on?
For recording the name of the opposite party number 1, Rajbihari Jana, and the petitioners have filed Can 3 of 2024 for recording the name of opposite party number 1, a petitioner number 1, Shankar Jana. Upon perusing both the applications, this court is of the view that the said applications should be allowed. Thus, the name of opposite party number 1, Rajbihari Jana, be deleted from the cause title, and the name of the legal heirs as mentioned in paragraph 4 of the application, Can 1 of 2019 be substituted in his place and state. The amendment be carried out within 2 weeks. With regard to application Can 3 of 2024, the said application stands allowed. Let the name of Shankar Jana be deleted from the cause title and leave be granted to his legal heirs to pursue this revisional application before this court. Thus, the name of the applicants heirs of Shankar Jana, as mentioned in paragraph 2 of this application Can 3 of 2024, be incorporated in place and state of Shankar Jana. The amendment be carried out within 2 weeks. Both Can 3 of 2024 and Can 1 of 2019 stands disposed.
It's gone.
Eight.
For this
2021 and the
opposite party.
petitioner, my lord, I'm praying for not today, my lord.
Okay, not this week.
Here I am appearing for
22, my lord. I am for the petitioner in this matter.
opposite party.
So hearing was concluded.
No, my lord. We have filed an application for addition of party, but we are not pressing that application. And my lord, we are.
So argue the main matter.
Yes, my lord. Your lordship, my lord, kindly fix the main matter on next Friday. Next Monday, my lord. We are.
The matter, they have filed their written notes of argument. It is there in the file.
So you have filed your written notes. What else remains?
This is with regard to my opposition, my lord. Kindly take this matter. I am led by Mr. Parthavati, my lord. Kindly take this matter next Monday, my lord.
You are the petitioner.
Yes, I am the petitioner, my lord. My application fee can, my lord. That is why I am not pressing the application.
No, argue the main matter.
Main matter kindly fix on next Monday, my lord. Kindly.
You have obtained several adjournments.
Kindly take my
This
lord,
is
next-
for the sixth time, my lord.
My lord, we are filing my opposition.
My
Your lordship,
dear friend
kindly
is a new in the matter, but this is for the sixth time they are praying for my lord. I'm highly prejudiced, my lord.
Yes,
Kindly.
learned advocates for the parties are present. Prayer for time is made on behalf of the petitioner. It is further submitted that the application can
1 of 2000.
Can 1
of 2026.
26 is not pressed by the applicants, thus the said stands dismissed for non-prosecution. Let this matter appear on 10/8/2026 as the last chance.
Hello, we are filing my opposition.
No, opposition, you are not present. Oh, opposition? Let the affidavit in reply filed to the revisional application be kept with the record. Yes, come next Monday.
Please, your lordship, I am for the petitioner.
সোমবার দিনে আসুন কালকে করে দেবো 24 তারিখে মেনশন
That is in regard to Lord, transfer of a case.
They have concluded argument on the last occasion. We have started.
Yes.
They have concluded their submissions. The
on the
petition,
last
I mean,
occasion.
on the last occasion.
No, this restoration application was allowed.
My lord,
There is an application for any application pending.
no application is pending.
Restoration application was allowed.
My lord, it was. Lord, on the last occasion, my lord, I started my argument. My lord, your lordship, thereafter adjourned the matter, and I have relied on few judgments, my lord, and my learned friend.
So argue the matter.
They have completed now.
What else is left?
It's a suit of 1985, my lord. It
Yes,
was
some
decreed-
decisions are relied upon.
My lord.
So you are coming against which order? That is order of the trial court.
No, my lord. Order of the appeal court.
Appeal court in?
Appeal court in order 9, rule 13.
Order 9?
Rule 13, my lord.
Rule 13. So order 9, rule 13 was dismissed by the trial court.
My lord.
Hereafter,
It was allowed by the appeal court.
the aggrieved party moved
My
an
lord.
appeal,
My lord.
and in the appeal court, order 9, rule 13 was allowed.
Order 9, rule 13 was allowed.
So appeal was allowed. Against that, you are aggrieved.
My lord.
So you submit.
They
You have relied upon 2 decisions also.
Yes, my lord. My lord, what happened in this matter, my lord, in the nutshell, my lord, I am just for your lordship's appraisal. Lord, it is a suit was filed in the year 1985. Thereafter, for eviction, my lord, before the city civil court. Thereafter, my lord, the defendant and the opposite party before your lordship, my lord, they preferred 7172. My lord, defense was struck off and it was disallowed. From then, the OP before your lordship, my lord, preferred a civil revisional application in the year 1992. During the pendency of the civil revisional application before this honorable court, my lord, what happened, my lord, that 1905 amendment, my lord, came. By virtue of that amendment, my lord, the matter has to go to this presidency small cause court. My lord, the comment is in the year 2000, that's what disturbed it. My lord, in the year 2001, COVID is Lord, thereafter, my lord, the civil revisional application was dismissed for default. In the civil revisional application, there was an order of stay. It was dismissed for default and all interim order vacated. Thereafter, my lord, the plaintiff and the petitioner before your lordship filed an application before the city civil court that in regard to the amendment, and by virtue of which, my lord, the matter was transferred. It was not transferred earlier because of the pendency of the civil revisional application. And during that period, my lord, the defendant opposite party, they preferred an application for transferring of the case. And it was, yes, that is from the face of the record, it is there. My lord, they preferred an application and apprised the learned court regarding the this amendment. My lord, the matter was not transferred because of the order of stay by the Honorable High Court. My lord, thereafter what happened? The suit was decreed ex parte. My lord, the suit was decreed ex parte. And the petitioner before your lordship filed an application before the city civil court that in regard to the amendment, my lord, the defendant opposite party, they preferred an application for transferring of the case. And it was, yes, that is from the face of the record, it is there. My lord, they preferred an application and apprised the learned court regarding the this amendment. My lord, the matter was not transferred because of the order of stay by the Honorable High Court. My lord, the opposite party defendant, they never appeared before the court
Before
despite
the,
of their due knowledge.
before the Presidency Small Causes Court.
Yes, my lord. After the transfer, but
So,
they are
written
well within the
statement-
knowledge
written statement
regarding
was
the
filed.
My lord,
Written statement was filed,
written statement was filed, and thereafter they have chosen not to appear.
but no cross examination. Any cross examination of the plaintiff's witnesses was done.
No, my lord.
Only
They have not
written
taken part.
statement.
Yes. At the 7-1-7-7-2 stage, my lord, it was transferred. Their defense was struck off. Thereafter, it was transferred. Thereafter, my lord, the matter went to the PH board, and after concluding the evidence, my lord, the suit was decreed ex parte. My lord, throughout, they were well within the knowledge in regard to the transfer, my lord. It is also reflecting from the impugned order. I am placing the impugned order before your lordship. And the appeal court went by a judgment which is not relevant so far as the present matter is concerned. That is my humble submission before your lordship. And considering, my lord, it's a suit of 1985. Now they are, my lord, it's a dilatory tactics, my lord. They are adopting, but that is why they purposely, my lord, they never appeared before the small cause court, and they are within the knowledge regarding they have inquired in regard to the, my lord, the transfer of the case. That is reflecting from the order itself. I'm placing the impugned order. My lord, the internal second page of the impugned order, my lord, and the second paragraph.
Page.
Internal page 2 of the impugned order, my lord.
Yes.
My lord, I am placing the second paragraph, my lord.
Yes.
It is for the case of the appellant. Appellant means, my lord, here the OP, my lord, the defendant appellant. It is for the case of the appellant that due to such circumstances, the appellant regularly contacted with their learned advocate for getting information of transfer of the record and the next date of hearing. That means, my lord, the OP, they were aware in regard to the transfer. They were aware so far as the amendment of 95 is concerned.
Yes.
And the learned trial court, my lord, was correctly dismissed the Order 9 Rule 13 application. The suit of 1985, my lord. Now they are trying to reopen everything.
Yes.
Now, my lord, I'm referring internal page 9 of the impugned order. এই জাজমেন্টটা বার করে জাজমেন্টের এখানে কপি আছে।
Yes.
Order with reason টা কোথায়? Lord, the learned appellate court, my lord, allowed the Order 9 Rule 13 application, my lord, relying, lord, two judgments which are not relevant, completely distinguishable.
You have a copy of the judgment?
My lord. এটা কোনটা? এটা কোনটা? This is one judgment, my lord. আমার কপি আছে এখানে বার কর। এই তো স্যার। হ্যাঁ, ICC. This is in regard to Order 6 Rule 30. হ্যাঁ, আর আরেকটা আছে দিল্লি সিআরওর ওপর দেখ। 17.4 ICC.
Yes.
And this is the another judgment. Lord, this is in my favor. Passed by Honorable Justice Meet Dara Shekho.
So on the basis of the Supreme Court judgment, the trial court came to the findings. The appeal court came to the findings.
Trial court, my lord, the
appeal court.
Appeal court, my lord.
So according to you, this
is a
decision
mandatory. My lord, in
according to
case
you,
of
this decision is not applicable.
My lord.
Okay.
And my lord, on the last occasion, I relied, my lord, at Supreme Court. But on the last occasion, I handed over a copy to your lordship, my lord. There is 2011 3 SCC 545. May I hand over again? একটাই copy আছে এটাকে mark করা Lord, this judgment is very clear. Page number টা কত?
545.
545. That in regard, that is, my lord, so far as the due diligence, where is the due diligence of the, my lord, petitioner? Lord, the Honorable Apex Court, my lord, emphasized on the due diligence. If there is no due diligence, then, my lord, there is no belief. না স্যার ওটা কোন জাজমেন্টটাই এটা তো Milord, the Milord, the 2008 ICC judgment, Milord, relied by the appellate court while passing the impugned order is in regard to, Milord, CRO of Delhi, and which is quite different from the Milord, West Bengal civil rules and order. Not in regard to this provision. No, sir.
Yes.
State amendment. State amendment. Here that is not mandatory. Milord, now I am relying, Milord, this 2011 judgment, Milord. Milord, I am relying on paragraph 13. Milord, Order 9, Rule 11, Rule 13.
Yes.
Milord, so far as Order 9, Rule 13 is concerned, Milord, there are two-fold of scopes, Milord. One is, Milord, notice was not, the summon was not served, and Milord, prevented by sufficient cause. Milord, here, Milord, so far as serving of summon is concerned, Milord, there is no dispute. Milord, the sufficient cause.
No,
Milord,
the written statement was filed.
Yes,
So
that
no
question is not there.
Yes.
Then another part of Order 9, Rule 13 is there. Milord, they are
The
saying
date
that
he
they are
failed to appear.
prevented by sufficient cause.
Yes, that is the
What is
question.
the sufficient cause, Milord? Milord, I am relying on, Milord, from paragraph 12, Milord. It is evident from the above that an ex parte decree against the defendant has to be set aside if a party satisfied the court
Yes.
that summon had not been duly served or he was prevented by sufficient cause from appearing when the suit was called on for hearing. However, the court shall not set aside the said decree on mere irregularity in the service of summon or in a case where the defendant had notice of the date and sufficient time to appear in the court. The legislature, in its wisdom, made the second proviso mandatory in nature. Thus, it is not permissible for a court to allow the application in utter disregard of the terms and condition incorporated in the second proviso herein. Para 13. Sufficient cause is an expression which has been used in a large number of statutes. The meaning of the word sufficient is adequate or enough, in as much as may be necessary to answer the purpose intended. Therefore, word sufficient embraces no more than that which provides a platitude which, when the act done, suffices to accomplish the purpose intended in the facts and circumstances existing in a case and duly examined from the viewpoint of a reasonable standard of a cautious man. I'm pausing here for a moment, Milord. I'm repeating, Milord. From the viewpoint of a reasonable standard of a cautious man. In this context, sufficient cause means that the party had not acted in a negligent manner, or there was a want of bona fide on its part in view of the facts and circumstances of a case, or the party cannot be alleged to have been not acting diligently or remaining inactive.
This is a proprietary concern. This defendant, tenant is a proprietary concern, or this partnership?
Partnership, Milord. And it is admitted, Milord, in the Milord, that the partners were examined and cross-examined.
Okay.
In regard to, Milord, Order 9, Rule 13 proceeding.
Yes.
They have admitted they are the partners.
So it's a partnership firm.
Partnership firm, Milord. Milord, here, Milord, this exactly the case, Milord, what is, Milord, stated here. That negligent manner, lack of bona fide, and, Milord, remaining inactive. Milord, I am most humbly submitting before your Lordship, Milord, it is reflecting from the entire record that they remained inactive. Now they are taking advantage of their own fault. It's a long pending suit, Milord. And when their defense was also struck off. Milord, I am not willing to waste your Lordship's valuable judicial hours, Milord. I am relying, Milord, para 16 of the same judgment. In order to determine the application under Order 9, Rule 13 CPC, the test that has to be applied is whether the defendant honestly and sincerely intended to remain present when the suit was called on for hearing and did his best to do so. Sufficient cause is thus the cause for which the defendant could not be blamed for his absence. Here, Milord, the defendant has to be blamed. And that is also reflecting from the impugned order before your Lordship. That so far as the amendment of 95 is concerned, that is within their knowledge. Thereafter, Milord, they stated, it is their submission in regard to the transfer. They inquired to their learned advocate. Then what prevented them? Merely saying this is sufficient cause is not a sufficient cause, Milord. Most humbly, I am submitting before your Lordship. And this judgment is very clear. So what is the parameter to allow, Milord, an application under Order 9, Rule 13? Therefore, the applicant must approach the court with a reasonable defense. Sufficient cause is a question of fact, and the court has to exercise its discretion in a varied and special circumstances in the case at hand. There cannot be a straitjacket formula of universal application. Yes, Milord, there should not be a straitjacket formula. But so far as the present matter is concerned, Milord, is this sufficient? I'm putting this question to myself. Considering, Milord, it's a suit of 1985. Defense struck off. It was stayed, my lord. It was not transferred in the year 95 because of their civil divisional application, which was again dismissed for default. Thereafter, it was transferred. The stay was lifted. Now they are saying that no notice and trying to take advantage of our technical reason.
No, the order of transfer was challenged in revisional application.
No, my lord.
Not.
Defense stuck off.
Okay, that was challenged.
That was challenged in long back in 92.
That was the challenge in revisional
92,
application.
yes.
Okay.
And
So-
that was admitted.
And the order was passed in 2004, 3-4.
It was dismissed.
So that was, so there was no challenge with regard to the order of
No,
transfer.
my lord. No.
Only with regard to the
Yes, my lord,
starting of
yes,
the defense.
Yes. Thereafter, the matter, during the pendency of that civil divisional application, my lord, the 95
So the
amendment.
suit was stayed.
Yes, my lord. That amendment, my lord, came. And by virtue of that amendment, the matter was initially filed before the City Civil Court. It was transferred to the Presidency Small Cause Court. And they were aware that is reflecting from the impugned order before your lordship. The second page, second paragraph. And the judgments they relied, and the also, my lord, relied by the appellate court, my lord, is not
So
relevant.
let us see how it is applicable to the facts of the case.
No, my lord, that is not applicable. And this present this judgment is applicable, my lord, this 2011 is. So it's SEC.
That's all.
I believe that is.
Yes.
My lord, by their eloquent, my lord, submissions, my lord, they are trying to relegate me to the sideline. It's absolutely not hard of. They are saying, my lord, please come to the paragraph, page, my lord, inner page 2. My lord, they are relying on that, my lord, that this judgment was passed by the appeal court, first appeal court, upon considering the record of the case. My lord, the main factor of the case is that when, in view of the new act, enactment of new act, West Bengal Premises Act, the entire proceeding of the whole ejectment suit was stayed. My lord. And in 2011, they started proceeding. They have started the process.
Let us see, consider the order.
My
Which
lord,
portion?
come to the page, my lord, inner page 2, they are relying on. It is further case of the appellant. Kindly see that impugned order, my lord. Page number, inner page 2, running page 43.
Yes, inner page 2.
Yes. It is further case of the appellant, my lord, paragraph 2.
Yes.
It is further case of the appellant that due to such circumstances, the appellant regularly contacted with the learned advocate. I regularly contacted my learned advocate. What else can I do, my lord? I cannot directly talk to the learned judge when my matter will be taken up. I entrusted my lawyer, I contacted, that is recorded. What they are saying? My lord, the learned advocate for getting information of transfer of the record and the next date of hearing. Learned advocate giving assurance. Learned advocate giving me assurance that yes, he will be informed as and when I will get the information from the court. And I rely on the learned advocate, my lord. My lord, next paragraph. It is further case of the appellant that there was a stay for further proceeding of the aforesaid suit in revisional application. Yes, that is the case of our. Up to 2003 or 4, my lord, the whole proceeding was stayed. And they started proceeding in 2011 or 2010 when the decree of expiry decree was passed without behind my back. My lord, they filed the application before the learned trial court. They have not given me notice, my lord. Learned court also did not give notice.
Revisional application, the earlier revisional application was contested.
It was contested, and my lord, that is regarding that against the reverse order passed in 17 2AB and 2. my lord. That is separate issue.
Now the question is, you see, so
My
for
lord, both-
revisional application
Yes.
filed in which year? Previous.
My lord, 92. 92. When the
When it
matter,
was disposed of?
2003.
Dismissed in 2003.
Yes, in my absence, my lord.
Okay. Dismissed for
This is
default?
Default, yes. That is also, my lord. My lord, kindly, my lord.
Okay, this is 2003.
Yes.
Okay. These are the matters of record.
Any matters of record.
Okay. Now, when was the suit transferred? Which date?
My lord, from the record, it appears that in 2008,
Okay. Transferred, suit transferred.
2008, they filed an application before the learned court. In
So now the question
It was
is,
transferred in
after
2005.
the dismissal order in 2003, will the records go to show that you had appeared before the city civil?
No.
No, after dismissal order?
No.
After dismissal order,
No.
in 2003, the suit was transferred in the 2008.
2005, Miller.
2000?
Yes.
2005.
So during these 2 years, was there any appearance by either of the parties?
They appeared in 2008.
Then I have to call for the record.
My lord,
I have to call for the trial
There
court
was an,
records.
at that point of time, there was an application না জজ সাহেব জিজ্ঞেস করছেন বলে বলছি স্যার
No, these are the matters of record. The trial court records are not
My lord,
here.
every record has been considered by the learned appeal
Okay,
court.
now the question
I'm
is,
answering your lordship's query, my lord. My lord,
2003.
during that period, my lord, there was an application pending before the trial court filed by them transfer.
Transfer?
And communicating that particular record, my lord,
It is
communicating
absolutely
the amendment of 95.
My lord, it is absolutely lie.
Yes, recorded
They have
order. Let me call,
communicated, my lord,
let
my
me
lord,
call for the
on-
trial
on-
court record.
My lord, one thing, my lord,
They have
only one
communicated, my lord.
submission.
See, let me go through the record. There's
My lord, certainly you will go through. Kindly one sentence, my lord. Decisions with the reason at interpret page 4. Kindly see.
No, the appeal court has
My lord,
assigned reason.
entire order was made by the trial court on presumption.
Yes, record and
My
order.
lord, only on presumption.
Learned advocates for the parties are present, hard learned advocates. Considering the facts of the case, this court is of the view that perusal of the trial court records are necessary. Thus, the trial court records be called for at the special messenger cost of the petitioner to be put in within 1 week. Let this matter appear on 17/8.
No, my lord, the 17, no, any day and the month of September, my lord. Because record will come.
Then again, my lord, it's a suit of 1985.
Okay,
my lord. I'm leaving it up to your lordship.
14/9.
I'm leaving it up to your lordship, my lord.
14/9/2026. Let the picture be clear. Who has acted bona
My
fide?
lord, my lord, my lord.
14/9/2026.
14.
The interim order granted earlier stands extended for a
Lord,
period.
that is reflecting from the impugned order also. It is recorded that they have apprised the court by filing an application. My lord, internal page 6 of the
So
impugned
that
order.
is why I want to clarify.
My lord,
Let
my
to
lord.
clarify. Was there any appearance by the parties between 2003 to 2005? What was the development? Yes,
My lord,
14.
That order has been made in the trial court on presumption.
That is recorded
That
in
is
the
recorded in the order.
that is recorded in the appeal court's order also.
14/9/2026, the interim order granted earlier stands extended for a period of 8 weeks or till further orders, whichever is earlier.
My lord, there is
Kindly have a look
there
at
is
my lord
no
page
valid
internal
interim
page 6 once.
My lord,
Lord,
in
if
this
you're
case, there is no interim order.
No,
So
the
extension
execution
does
case
not
is
add-
being proceeded with.
No interim order.
Anyway, I've passed that order.
my lord, in the internal page, my lord, 6 of the impugned order by the appellate court's order, my lord, it is recorded in the last paragraph, my lord.
Anyway,
they
if the
apprise.
records come, both of you
My
go through the records,
my
make necessary submissions.
My lord, I have gone through the record, my lord, and
I have also gone through
Let
the
your learned friend also go through the
observation-
records.
My lord, the observation made in the appeal court order, my lord, it is clear, my lord.
Okay. 14/9.
Get to
Item 14. Yes, call 13/14. Both parties are present.
Yes.
Yes.
My learned senior is present.
Huh? He. Modification.
My lord,
Okay, just a minute. Let 24 be called on thereafter.
LCR will be brought on at the cost of the, my lord, they will take the petition,
Yes, I've stated that.
the petitioner.
Lordship, I'm appearing on behalf of the petitioner. Your Lordship, this is a modification application and
I am for the opposite party.
So it is their modification application.
Yes.
So are you opposing?
State Bank of India.
Are you opposing that?
Yes, my lord, opposing, my lord,
Then you file your opposition.
subject to correction, my lord, does not have determination of this matter.
Okay, okay. Then it has to be 2020.
No, my lord, this is a disposed of matter, my lord, recalling of a disposed of matter.
Oh, then it is to be should be taken up by the judge having determination.
No, my lord, that judge, my honorable judge has already retired. My lord, Justice Apurva Sinha Roy, subject to correction, has been given the determination of
Okay.
review.
My lords, if I may,
All judges.
I am appearing in this matter for the
Learned advocates for the parties are present, as this bench does not have the determination to take up the review or recalling on modification of an order which is passed by a learned judge who has already retired. Let this matter be placed before the honorable bench having the determination. Okay. The matter stands released.
This was disposed of by Justice Bivas Ranjan.
Yes, that is why His Lordship Justice Sinha is given the determination. Let it be placed before His Lordship. So I am releasing this matter. Yes, call the Passover matter.
My lord, only just 1 minute it will take. My lord, item number 25 and 26, my lord. My lord,
I was supposed to file a supplementary, which I need a little extension, and there was an interim order.
Yes, record an order. Learned advocates for the parties are present. Prayer for time is made by the learned advocate for the petitioner.
To file the supplementary.
Learned advocate for the parties are present. Prayer for time is made by the learned advocate for the petitioner. The matter stands adjourned till 10/8/2026. Next Monday.
so, my lord,
My lord,
thereafter,
next-
my lord, I am to file the reply because my lord, his supplementary.
Okay.
My lord gives me time till 17th August.
Okay,
my lord,
17/8/2026.
Thereafter, my lord, another 10 days, my lord, may be given to me, my lord, to affirm the reply.
Sure. That the time to file supplementary affidavit stands extended till 17/8/2026. Reply, if any, by 7/9/2026. Let this matter appear on 14/9/2026.
My lord, interim order, my lord, may be extended
Interim order
in
stands
the month of September. My lord, I do not
extended
have any objection.
for a period of 9 weeks
9
or till further orders, whichever is earlier.
Very grateful. Very grateful, my lord.
Hey, Nam.
May it please the Lordship.
I'm for the opposite party.
Yes, previous day I passed an order regarding that the instruction and report with
Regarding
regard to
the-
valuation.
Valuation of the sales certificate.
Yes, what is your instruction now?
Come Lord, as far as my instructions are, we have made searches, we have found that the sales certificate has not been registered. And as far as the other side is concerned, they were supposed to come back to your Lordship with definitive
দেখি
instructions
অর্ডারটা
on
দেখি
that.
লাস্ট অর্ডারটা
Please come to the second last effective paragraph at page 2. In the facts and circumstances, the matter stands adjourned till 13th July,
No, just a minute. 15/5/2026.
29th June 2026.
29 June 2026. এই দেখি 29 জুনের অর্ডারটা এটা তো অন্য ম্যাটার দিয়েছে 14-15টা দিন
কত 13 তো কত নম্বর ম্যাটার আমাদের 13 আর 14
Yes. Yes, sale deed was to be produced, which was executed. That was the direction.
And the second last paragraph of page 2,
Yes.
in the facts and circumstances, matter stands adjourned till 13th of July for the learned advocate of the opposite party to ascertain as to whether the sale document was registered. In the event sale document is registered, to obtain necessary particulars of the same.
So
Now,
sale
learned friend
certificate is
before-
there.
Yes,
Only
I
they have filed the sale certificate.
Yes, I have taken instruction, my lord, that the sales certificate is not registered.
Sales certificate is not registered.
Then you see, value, everything depends upon the valuation. Let me appoint a special officer to ascertain the valuation.
No, my lord, I will not assist you in this way. The valuation of that sales certificate of the property which has changed hands is another issue. It's important, but it's slightly
On that time,
at that point,
valuation at
yes,
that
yes, at
time.
that point of time. But that's a tertiary issue. The main issue which we are agitating before your lordship is that this entire sale took place in a manner which has three-pronged illegalities which strike at the root. Number one, that the process of finding the highest price was completely vitiated. Number two, that there was no wide publication of the notice that was given, and as a result, appropriate participants could not be brought in. Number three, very shockingly, a cartel was formed, and on behalf of that cartel, that entire purported process of bidding was in fact taken over by the cartel to ensure that
Those will be considered as well as with valuation. Entire aspect is to be taken into consideration for arriving at a decision. That is why it is necessary. That is why for the last 3 weeks, I am passing this order. Yes, record an order. Learned advocates for the parties are present. Hard learned advocates by order dated 15/6/2026. At the outset, the learned advocates for the parties are requested to produce a copy of the sale deed which was executed in the auction as per order of the Trade Recovery Tribunal to ascertain the market value and the stamp duty paid. Subsequently, by order dated 29/6/2026, the learned advocates for the opposite party was granted opportunity to ascertain as to whether the sale document was registered. In the event the sale document is not registered, in the event the sale document is registered, to obtain necessary particulars of the same. Now, when was the date of the issuance of sale certificate?
sale certificate copy, my lord, was filed by them.
Sale certificate and the sale, that is what? Same time.
The sale certificate is dated the 26th August 2005. 26th August 2005.
It appears from the sale certificate, the sale certificate in the instant case was issued on 26/8/2005. Stop. Upon hearing the learned advocates on the issue, this court is of the view that the valuation of the property at 26/8/2005 is very much necessary to ascertain as to whether the order passed by the learned tribunal is perverse, along with consideration of other issues. Thus, this court appoints dash dash as the special officers to cause an inquiry at the register, at the district register, Malda probably.
My lord, may I humbly submit this? Your lordship may appoint a special officer.
Yes.
Otherwise, I was just thinking, my lord is the 227 court, wide powers. If my lord can direct the concerned
That will take
registrar,
time. That will
the
take
concerned registrar to file a report stating the valuation of the property as on that.
let him go and collect the report from the district registrar Malda as to the valuation of the property which was directed to be sold by the Learned Trade Recovery Appellate Tribunal. Upon collecting the valuation of the property, the learned special officer shall submit the report. Learned special officers shall, upon notice to both parties and their learned advocates, cause necessary inquiry with regard to the valuation.
Lord, the registering authority will cooperate, render all cooperation.
The registering authority in the district of Malda shall render all necessary cooperation to the learned special officers. Let this matter appear on 14/9/2026 for report of the special officer and further orders.
My lord, kindly record the petitioner and the opposite party number 2 because bank is not representing before your lordship. The appearance.
Okay, whatever it is, whoever are the parties here.
Yes.
And the remuneration to be borne equally. Both parties are interested involved equally.
My lord,
Remuneration, yes.
by property, if my lord can just indicate.
The learned advocates are requested to give necessary particulars of the order of the debt recovery tribunal which is challenged in this application and the particulars
And a copy of the sale certificate.
and copy of the sale certificate and necessary particulars of the property to the learned special officer
The sale
for
certificate.
necessary inquiry.
Yes. Now, my lord, only one thing. Now, my lord, as far as this is concerned, the property by the property, my lord would maybe my lord would want to clarify the property specified in the sale certificate.
Yes,
The property specified in the sale certificate.
Specified in the sale certificate.
So that
From that the inquiry will be held.
From that the inquiry.
14-9.
27.
Lordship for the petitioner.
Lord, would your lordship, Lord, another because sufficient time has been given to this.
Because at the end of August, this bench may not sit due to circuit. That is why I had to keep it in the month of
No
September.
difficulty. I'm only one thing. Would your lordship, Lord, make an observation that the time limit for filing the report is peremptory. Other, if he has any difficulty, he can come up. The time limit is peremptory.
Learned special officer shall
Peremptorily
all
file.
necessary steps and shall all necessary steps that the report is filed within the date fixed without delay.
Obliged, your lordship. Most obliged.
Lordship, I appear for the petitioner. The matter needs to be heard. It has already been heard in part. Lordship may fix it on next Monday, somewhere at the top of the list, so that because we need 1 day to complete the arguments, your lordship.
So this matter was heard in the absence of the. Oh, you are appearing.
No, I'm 28 active.
Okay.
28.
So
No, she's not appearing. She's not appearing in 20. Lordship may fix it next
question
day.
is, what is the impugned order?
Lordship.
Respondent, this opposite party has entered appearance.
Yes, your lordship. Mr. Shaunak Bhattacharya only was
Oh,
appearing.
Mr. Bhattacharya is present. So
Yes,
I'm keeping it next week.
Lordship may keep it at least at some point so that it needs to be heard. We just need 1 day
It will
to
appear. The learned advocate for the petitioner is present. The matter stands adjourned till 10/8/2026. Interim order is continuing.
Yes, your lordship. It's on the last occasion, lordship had extended it. It's till 7th of September. Gratefully, lordship.
Yes. Next.
No, I didn't know 28 method.
Yes. Let it be called on.
In person.
Let it be called on, please.
Extremely sorry. Extremely sorry.
Item 28.
Yes,
sir. She's appearing in person.
I'm the petitioner.
আপনার কি কোনো মানে লয়ার নেই ম্যাটারে?
না স্যার, আমি in person move করব।
তা আপনার অসুবিধা কি এটা কোনো লয়ার রাখতে?
না
So,
স্যার,
she's reported before the court of law that she's not getting.
স্যার আমি সব কোর্টেই in person ই মুভ করি।
No, no.
না
যদি আমাকে
এটা লিগ্যাল প্লিজ এটা একটা লিগ্যাল ম্যাটার তো আইনের।
কিন্তু আমাকে লয়ার কোনো কোর্টে রাখতে দেওয়া হয়নি এবং লয়ার
না,
আমার অনেক
ব্যাপারটা হলো
ক্ষতি
দেখুন,
হয়েছে।
ব্যাপারটা শুনুন।
স্যার আমি সবটা বুঝতে আপনি
ব্যাপারটা-
আমার কথাটা আমাকে একটু 5
হ্যাঁ।
মিনিট সময় দিন স্যার। আমি ম্যাটারটা বলি, তারপরে যদি আপনার মনে হয় যে
তো আমার তো মনে হচ্ছে কারণ আইন নইলে মনে না হলে আপনাকে আমি বলতাম না, আমি
আমাকে
সময়
একটু-
নষ্ট করতাম না।
স্যার একটু
কারণ ব্যাপারটা দেখুন, আপনি আপনার বক্তব্য করবেন, আইনের বিভিন্ন দিক আছে, শুধু আপনার কাগজ দেখলেই চলবে না, আইনের বিভিন্ন দিক আছে, সেটাকে বিশ্লেষণ করা দরকার। ব্যাপার
আমি কোনো কোর্টে লয়ার রাখতে পারিনি, আমাকে রাখতে দেওয়া হয়নি।
না রাখতে কেন দেওয়া হয়নি আপনাকে?
স্যার আমার
প্লিজ কি অসুবিধা হয়েছে কি? আর
স্যার
দেখুন, হাইকোর্টে একটা লিগ্যাল সার্ভিস অথরিটি আছে,
স্যার
এখানে আপনি বিনামূল্যে লয়ার পাবেন।
স্যার আমি জানি,
তাহলে আপনার যেখানে আপনি
কিন্তু
বিনামূল্যে
আজকে-
লয়ার পাবেন, একটা লয়ারের অ্যাসিস্ট্যান্স দরকার। এটা আপনার দৈনন্দিন একটা সমস্যা নয়।
স্যার সব আমি জানি, কিন্তু আমি যদি আজকে রাখতে পারতাম মানে আমার যদি লয়ার দাঁড়াতো তাহলে স্যার আমাকে হাইকোর্ট অব্দি আসতে হতো না, আমাকে লোয়ার কোর্ট থেকে আমি বাড়ি চলে যেতাম।
সেটা ঠিক আছে,
আপনি স্যার বুঝতে
এখানে অসুবিধাটা কোথায় আছে?
আপনি স্যার ম্যাটারটা একটু দেখুন, তাহলে আপনি বুঝতে পারবেন।
আমি ধরুন আপনাকে শুনলাম, ব্যাপারটা কি জানেন তো, আইনের বিশ্লেষণটা একটা সাধারণ
স্যার-
মানুষের চেয়ে তো লয়াররা ভালো করতে পারবে।
স্যার আমি হাইকোর্টে প্রচুর ম্যাটার করে গেছি ইন পার্সন, এবং সুপ্রিম কোর্টেও আমি ইন পার্সন মুভ করি।
না প্রশ্নটা দেখুন, আমি আমার কথা বলছি, সেটা হলো এটা আইনের দিকে এটা
আমি
বিশ্লেষণ করতে গেলে এখানে কি আছে কি আপনার কি অর্ডারটা দিয়েছে দেখি আগে
স্যার অর্ডারটা দেখুন লাস্টে আছে
একটু বলতে পারি
Now let me see the impugned order which is under challenge.
একদম লাস্ট পোরশন
There I have some differences, man.
Sir.
Please respect. I have got some
Dekhi,
differences.
dekhi, please let which is the where is the order under challenge?
My lord, this is the copy which has been saying to me. There is no, it doesn't carry any impugned order. I had to accumulate the impugned order.
আমাকে একটু কাইন্ডলি
I'm reading it out.
স্যার আমাকে
My lord,
একটু
please
কাইন্ডলি
mark
বলতে
that.
দিন
Where is the order under challenge?
My lord,
যে
I have
অর্ডারটা
not-
চ্যালেঞ্জ হচ্ছে অর্ডার নাম্বার 37
Don't have the copy. Okay. Let me see.
37 dated 19/12/2024
Okay.
জজ সাহেবকে দিয়ে দিন তো, দেখুন এটা আমার কপি আমাকে দেয়নি, বুঝে দেবেন জজ সাহেবকে। He has not provided any impugned order to me. My lord, if you lord, in order to assist your lordship, I beg to draw the kind attention of your lordship.
আপনি ট্রায়াল কোর্টে কি প্লেন্টিভ
স্যার না আমি ডিফেন্ডেন্ট
ডিফেন্ডেন্ট মামলাটা কি নিয়ে কিসের ব্যাপার
মামলা
নিয়ে
498 ডিসমিস হয়ে যাওয়ার পর আমার হাজবেন্ড এবং ওনার এল্ডার ব্রাদার আমার এগেইনস্টে 45 লাখস এর একটি মানি শুট ফাইল করেন
মানে মানহানির মামলা
মানহানির মামলা করেন স্যার আমি একটু বলতে পারি
আমি দেখি আগে অর্ডারটা কি
Okay,
পাস
sir.
করেছে
Yes.
You have not received with the copy of the impugned order.
I have not got the copy of the impugned order because, my lord, I am telling your lordship, kindly come to the review portion impugned order. Her claim regarding the business of the honorable court regarding a matter cannot be considered as a condemnable excuse as the court of civil procedure, specifically but business of counsels in other courts. Thereafter, my lord, thereafter her unscrupulousness is quite heavy.
No, you want a copy of the order, the copy can be supplied to you. You come ready on the next day.
Got it from otherwise. I've got it otherwise. I'm not waiting for her. When you unscrupulous litigate, my lord, she has adapted all unfair immunities.
না স্যার আমাকে একটু কাইন্ডলি স্যার আমাকে একটু বলতে দিন স্যার
Only
আমাকে
for
5 মিনিট
26
একটু
days, only for 26 days matrimonial life, my lord, she has got more than 20
Yes,
from my
বলুন না কি
life.
আছে
স্যার আমি এই কেসে যখন এফিডেভিট ইন চিফ ফাইল করি তখন তার সাথে কিছু ডকুমেন্টসও ফাইল করেছিলাম কিন্তু ডকুমেন্টস গুলো সেই সময় আমি টেন্ডার করতে পারিনি কারণ যিনি পিও আছেন তিনি আমাকে বলেছিলেন যে ডকুমেন্টস গুলো সেকেন্ডারি এভিডেন্স তো ডকুমেন্টস গুলো টেন্ডার করা যাবে না কিন্তু এনার আগে যিনি পিও ছিলেন তিনি আমাকে বলেছিলেন ডকুমেন্টস গুলো যদি ডিউলি সাইন্ড হয় এবং যখন আপনি ক্রস করবেন তখন পার্টির হাতে ডকুমেন্টস গুলো দেবেন তিনি যদি অ্যাডমিট করেন তাহলে সেগুলো আপনি এক্সিবিট করতে পারবেন। আমি তাই করেছিলাম। ওনার হাতে ডকুমেন্টসগুলো প্রত্যেকটা দেয়া এবং উনি কোনো অবজেকশন না দিয়ে ডকুমেন্টসগুলো অ্যাডমিট করেছেন। এবং আমার স্যার মান্থলি মেনটেন্যান্স 10,000। তো আমার পক্ষে স্যার বারবার করে অরিজিনাল আমার কাছে আছে, আমি ওনাকে দেখাতেও চেয়েছিলাম, কিন্তু আমার পক্ষে স্যার বারবার করে অরিজিনাল ডকুমেন্টস তোলা সম্ভব নয়। তাই জন্য আমি ওনাকে বলেছিলাম অরিজিনালেরই সেকেন্ডারি এভিডেন্স আমি আপনাকে দিচ্ছি। তো উনি তখন সেই ম্যাটারটারই স্যার হিয়ারিং হবার কথা ছিল 14ই নভেম্বর 2024-এ। কিন্তু সেই দিন হাইকোর্টে একটা রিট পিটিশন থাকে আমার, সেখানেও যেহেতু আমি ইন পার্সন মুভ করছি তাই জন্য আমি সেখানে প্রেজেন্ট হতে পারিনি বারুইপুরে। তো নর্মালি স্যার 2 থেকে 3 দিনের মধ্যে সিআইএসএস এর নেক্সট ডেট এবং অর্ডার চলে আসে, কিন্তু সেবারে আপ টু 2nd ডিসেম্বর মর্নিং অবধি কোনো রকম কিছু শো করছিল না সিআইএসএ। তখন আমি কোর্টে পৌঁছই এবং কোর্টে পৌঁছে ওনাদের কস্ট লিস্ট চেক করে আমি দেখি যে 14ই নভেম্বরের পর আরেকটা ডেট পড়েছে 27শে নভেম্বর, এবং সেই ডেটটাও যেহেতু সিআইএসএ মেনশন ছিল না তাই 27শে নভেম্বরও আমি যেতে পারিনি। তো আমার স্যার এভিডেন্স ক্লোজ করা হয়েছে, কারণ 27শে নভেম্বরই আমাকে লাস্ট এভিডেন্সের সুযোগ দেওয়া হয়েছিল এবং কেসটা ডাইরেক্ট আর্গুমেন্ট স্টেজে পৌঁছে গেছে। আর্গুমেন্ট ডেট ফিক্সড করা হয়েছে স্যার 18 ডিসেম্বর 2024। তখন ওনাদের কথা মতোই আমি একটা পুট আপ পিটিশন ফাইল করি 6 ডিসেম্বর 2024। সেখানে আমি মেনশন করি যে স্যার এত শর্ট ডেট মানে 14 থেকে 27-এর মধ্যে এই যে গ্যাপিংটা, এটার মধ্যে এর আগে কখনো ডেট পড়েনি এবং সিআইএসএ এটা মেনশন করা ছিল না বলে আমি আসতে পারিনি। আমি একটা স্ক্রিনশট ওনাদের দিই। তখন ওনারা যে অর্ডারটা করেছেন সেটার বেসিসেই এই অর্ডারটা করেছেন স্যার। উনি লিখছেন, so far as short date is concerned, this is a money suit of 2019 and as per the tracking of the suit as laid down by the Honorable High Court Calcutta, this suit was supposed to reach its end within 1 year. যদি স্যার 1 ইয়ারের মধ্যে শেষ করে দেবার কথা থাকে তাহলে স্যার ওনার আসার পর থেকে প্রত্যেকটা ডেটই এরকম শর্ট পড়তে পারতো, কিন্তু আপনি ওনাদের অপোজিশনটা যদি দেখেন স্যার পেজ নাম্বার 32 কাইন্ডলি একবার খুলবেন।
পিটিশন তো ওনাদের থাকবে না,
হ্যাঁ স্যার,
ওনারা তো প্লেন্টিফ, অপোজিশন আপনার থাকবে যে রিটেন স্টেটমেন্ট।
এই কেসে আমি পিটিশনার।
ও আচ্ছা আচ্ছা, ঠিক আছে।
তো স্যার অপোজিশনটা কাইন্ডলি একবার যদি খোলেন
বলুন
পেজ নাম্বার 32,
বলুন।
এখানে যে ডেটগুলো দেয়া আছে দেখুন, ওনার আসার পর যে ডেটগুলো উনি দিয়েছেন 18/12/23, তারপরে 18/1/2024, 19/3/2024, 9/4/2024, তারপরে 14 থেকে 27-এর মধ্যে এই 10-12 দিনের ডিফারেন্সে উনি এর আগে কখনো কোনো ম্যাটার দেননি।
কি আছে উনার দেওয়া দিয়ে কিছু না, কোর্ট যদি মনে করে যে শর্ট ডেট দেবে কোর্ট দিতে পারে।
কিন্তু স্যার লাস্টে উনি আমাকে বলছেন যে আমি দিস ইজ এ অ্যাবসলিউট মিসলিডিং ডকুমেন্ট। ওনাকে যে আমি ডকুমেন্টসটা দিয়েছিলাম যেটা স্ক্রিনশট ছিল সেটার ব্যাপারে উনি লিখছেন দিস ইজ এ অ্যাবসলিউট মিসলিডিং ডকুমেন্ট। দিস ডিফেন্ডেন্ট ক্লিকড অন দ্য ডেট প্রিভিয়াস টু দ্য 14/11/2024 on 2/12/2024 which showed 14/11/2024 as the next hearing date. This function is known to all and sundry who use the CIS. Thus, the court is of the view that the defendant tried to fool the court and get an order passed her choice. At this stage, this court restrained itself from taking legal action against the defendant at this hour, but reserve this right to do so when situation is demand. অথচ এই উনি বলছেন এটা আমি মিসলিডিং ডকুমেন্ট দিয়েছি সিআইএস এর এই স্ক্রিনশটটা, অথচ এই অর্ডারের লাস্ট পোরশনটা দেখুন স্যার, ফিক্স 24/12/2025, ওটাকে কারেকশন করে করা হয়েছে 2024 স্যার, এবং কারেকশনটা করা হয়েছে কবে দেখুন, যেদিন আর্গুমেন্টের ডেট ফিক্সড আছে 24/12/2024।
অ্যাপ্লিকেশনটা কবে কাজ ছিল? 6/12/24 না 6/12/25?
25 ছিল প্রথমে,
ছিল তার, ঠিক আছে, ওটাই কারেক্ট।
সিআইএস এ 2025 ছিল, মানে 1 বছর পর, অথচ আর্গুমেন্টের ডেট ফিক্স আছে 24/12/2024 এ। স্যার আমার সন্দেহ হয় মানে এখানে উনি বলছেন 1 বছরের মধ্যে শেষ করতে হবে, অথচ আর্গুমেন্টের ডেট উনি ফিক্সড করছেন 2025 এ। বোথ সাইড মাস্ট কাম রেডি।
1 বছর পরে তো আর্গুমেন্টেড ডেট হয় না, তাহলে যদি ভুল করে দিয়েও থাকে তাহলে সেটাকে ঠিক করতে হবে।
কতবার স্যার আমার এই ভুলটাতে আমি তো সাফার করতাম, 1 বছর পরে যদি আমি পৌঁছতাম কোর্টে তাহলে স্যার আমার সবই হয়ে যেত ওখানে। শুধু আমাকে একবার নয় স্যার, আমার সঙ্গে এরকম বহুবার করা হয়েছে। আমাকে
এটা 2000 মামলা
দেখুন এক্সপার্টি করা পর্যন্ত হয়েছিল আমাকে, বারবার ভুল ডেট দিয়ে।
ব্যাপারটা শুনুন, আপনার সমস্যাটা বুঝতে পারছি যে
স্যার,
এরকম এরকম কনফিউশন, কোন ডকুমেন্টস প্লেস করা, উপস্থিত না থাকা, আপনার সমস্যা বুঝছি। কারণ আপনাকে
বারবার ভুল ডেট দিয়ে এগুলো কনফিউশন, প্রিসিডিং ডকুমেন্ট আমাকে দিচ্ছেন।
আপনার সমস্যাটা বুঝতে পারছি। এই সমস্যাটাই মামলা নিষ্পত্তি করে দিলে সমাধান হবে না, মামলা যাবে, আবার আপনি সমস্যায় পড়বেন। তার মেইন কারণটা হলো আপনি লয়ার এনগেজ করেননি।
না
আপনি
স্যার,
আপনি এনগেজ না করলে আবার প্রবলেম হবে।
পারবো না।
তাহলে প্রবলেমে পড়তে হবে। আপনি
এটা তো ইচ্ছাকৃত করা হচ্ছে আমার সাথে।
ইচ্ছাকৃত নয়।
ইচ্ছাকৃত, আপনি বারবার ভুল
কোনো ইচ্ছাকৃত নয়।
আমি প্রুফ দিচ্ছি তো।
আপনার ওই কাগজটা ওটা প্রুফের পক্ষে যথেষ্ট নয়। আমি ট্রায়াল কোর্ট রেকর্ডস কল ফর করব, তারপর আমি দেখব। ইয়েস, রেকর্ড অন অর্ডার। Learned advocates for the parties are present. Sorry, the learned advocate for the opposite party number.
Opposite parties.
Opposite parties is present. The petitioner is appearing in person, is also present. Heard the petitioner appearing in person.
ফাইল হয়ে গেছে, জাজমেন্টও পাস হয়েছে।
This court is of the view.
তো কাইন্ডলি যদি একটু তাড়াতাড়ি ডেট রাখেন।
The appeal is the judgment.
হ্যাঁ স্যার, জাজমেন্ট
তাহলে দেখুন, ডিগ্রি যদি পাস হয়ে গিয়ে থাকে না, তাহলে ডিগ্রি পাস হয়ে গিয়ে থাকলে এই অ্যাপ্লিকেশনটি ইনফ্রাকচারাস। আপনাকে করতে হবে কি, ওই অ্যাপিলে যে ডিগ্রিটা পাস হয়েছে, যা বক্তব্য আজ এখানে বলছেন, তো ওই অ্যাপিলের মধ্যে সেটাকে বলতে হবে। আমি লিবার্টিটা দিয়ে দিচ্ছি আপনাকে।
ওকে স্যার, থ্যাংক ইউ।
My lord, before granting his liberty, kindly I beg to draw the kind attention of your lordship that after the case has been decreed, she has appeared before the court of law in Honorable High Court.
No, this application is filed prior to the decree or after the decree?
No,
prior to the degree.
This revisional application.
Sir, prior.
Just a minute. Learned advocate for the opposite parties and the petitioner who is appearing in person are present. Heard the petitioner who is appearing in person. Stop. As
Sir,
the money suit number 15 of 2019.
স্যার আমি একটা কথা বলছি এর মধ্যে।
দাঁড়ান একটু, just money suit number 15 of 2019, in which order number 37 dated 19/12/2024 is under challenge in this revisional application being CO 363 of 2025 is already disposed. This application has become infructuous. Stop. As this application has become infructuous, there is no scope to pass any order in this revisional application. Stop. It is hereby made clear that কি বলুন
স্যার, বলছি যে আমি এখানে মানে এই কেসে যেহেতু কোনো রকম ডকুমেন্টস ফাইল করতে পারিনি, মানে টেন্ডার করতে পারিনি, সেই জন্য কেসটা ওনাদের ফেভারে গেছে এবং 6 মাসের মধ্যে আমাকে 11 লাখ টাকা।
এই পয়েন্টগুলো আপনি অ্যাপিলে নিতে পারবেন, আমি ক্লিয়ার করে দিচ্ছি। ইয়েস, ইট ইজ
স্যার ডকুমেন্টসগুলো যাতে টেন্ডার।
No, nothing to hear you.
My lord, I have submitted that document.
স্যার
You are submitting. Yes, you have submitted document.
Cost.
আচ্ছা,
get cost by decide.
আচ্ছা কি লিখলাম বলুন তো? না challenge. আচ্ছা,
as this application has become infructuous, there is
no scope
to pass any order in this
division. It is however made clear
স্যার আপনি
that this court
যাতে আমি
has
ডকুমেন্টস
not gone into this merits of the case, and the parties will be at liberty to take necessary points in the appeal, which is already preferred before this honorable court against the judgment and decree passed in money suit number 15 of 2019.
স্যার আমি স্যার এক সেকেন্ড স্যার,
two judgments for an entitled to get cost, my lord.
Sir,
see, my lord, I have when the appeal filed, my affidavit was in force.
স্যার আমি ডকুমেন্টস গুলো যাতে টেন্ডার করতে পারি কাইন্ডলি ওই প্রভিশন।
সব লিবার্টি দিয়েছি, all points are kept open.
ওকে থ্যাংক ইউ স্যার।
Disposed.
Your lordship will consider my case, my lord.
You go get your case heard before the appeal court. Appeal has been preferred. All points are kept open. I've made it clear.
29.
Appear for the opposite party.
I appear for the defendant number 6 petitioner. Now, my application under
You
order
are appearing for
petitioner.
defendant number 6 petitioner, yes.
My kindly see me the impugned order dated 30th November 2024.
Yes.
Lord, my application under order 14 rule 2 of the Code of Civil Procedure, my lord, has been rejected.
You are the petitioner, plaintiff opposite party. So, what was this order? So, your prayer to fix the maintainability as a preliminary issue
Has been rejected. Has been rejected.
Yes, you want the dismissal of the suit
Yes, yes.
on the ground of non-maintainability.
On maintainability, we filed application under the RTI Right to Information Act before the TICA controller. Now TICA controller has given us a reply that there are huts and the TICA the property is otherwise TICA property.
So, what is the case of the plaintiff in the trial court?
For eviction, my lord.
Yes, eviction suit.
Eviction of tenant or licensee?
Tenant.
Eviction of tenant.
Tenant.
My lord, that we don't say, my lord, the eviction suit is not maintainable. It is maintainable, but before the Tika controller. We are on the jurisdiction. In view of Milord Section 8 and 21 of the West Bengal the Tika Controller Regulation and Acquisition Act.
So according to the plaintiff, it is not a Tika property. To their application, you have disputed that it is a.
Yes, just given me one.
Yes.
Yes.
They have filed an application on Order 14 Rule 1 with a copy of a RTI reply saying that it's a Tika property, but that RTI document was not also served upon us with the application. If my lord kindly see the second paragraph of the application, my lord, the learned advocate of the plaintiff filed a written objection against the said aforesaid application, submits the application filed by the defendant not maintainable in law and is barred by so and so. Plaintiff stated that although defendant stated that information through RTI has been filed along with the application, but no copy of the said annexure was served upon the plaintiff. We are not aware what is the
I mean, the court has not gone into that. Court has rejected it on maintainability.
No copy. Now the court is of opinion this document has to be marked as an exhibit and decided on trial. Kindly see the last portion, my lord. The last page, therefore, from the above discussion, it can be said the issue so framed is answered negative at this stage of the suit. The suit can be decided properly after recording evidence in the suit. So the document, that RTI document, which they are saying is a property of the Tika, which I am not aware with whether the RTI response, the court is opinion that this document has to be marked as an exhibit, and after trial, this issue can be decided. At this stage, this issue has been, but the main issue let be framed and let it be decided after recording
So the decision relied upon by the trial court. That is, this is the decision.
Yes, the court is of opinion that
you have a copy of this decision.
No, my lord. I can bring it, my lord. I can bring it.
The court is of opinion this document which there is not within the four corners, because in the written statement also this point was not taken. They have filed 7172 application in connection of this eviction suit also. Now they have filed an application saying this document, this property is as per they claim there is a Tika property, which I have saying that is not at all a Tika property. Further, the RTI response.
You have denied that in the application.
Yes, in objection I have stated so. Now let this if he says that Tika property, let that be marked as exhibit. Let it be tried upon proper evidence whether it's a
that
Tika.
issue. That issue itself. Anyway, bring a copy of the decision. Okay.
Very well.
On the next day.
Very well.
Learned advocates for the parties are present. Hard learned advocates. Let this matter appear for further hearing on 10/8/2026. Next Monday.
Affidavit of service is taken on record.
The affidavit.
Preferably at a top, my lord.
Yes.
Preferably at a top, my lord.
It will be taken up.
On Tuesday, my lord. On Tuesday.
No, my revisional applications are taken on Monday. Then thereafter, next Monday.
Any day, my lord, Monday, my lord, there is a matter fixed before the Honorable
17/8.
Yes, before the Honorable Division Bench presided over Justice Shobhajaji Bhattacharya.
My suit has been stayed, my that
So another thing I can do on this, if you come on 10th, I can keep it at 2 p.m. or 3
Yeah, kindly fix it 2 p.m.
Matter appear on
or Tuesday, my lord, any day.
Let it be on Monday. Monday 10/8/2026 দুটোর সময় দেখুন কি 3টের সময় কিংবা 4টের সময়।
না 3:30 হয়ে যাবে তখন আর ফ্রাইডে ছাড়া হয় না।
10/8/2026 at 3 p.m.
Yeah, my lord, I have engaged by the insurance company. I have to file my Bhokaradama also.
দেখি রেকর্ডটা একটু।
This is the case of 2008, my lord.
A case of dismissal, I think.
ঠিক আছে।
For enhancement.
Oh, dismiss হোক আর allow হোক। I have already informed the insurance company on 24th.
Paper books are ready. Entire things are ready. So you are appearing for New India Assurance Company. It is a case of dismissal.
Yes.
Yes. So you have been served with a copy of the paper book.
Yes.
Incomplete paper book, yes, taken.
Not incomplete. They are opposite.
তুমি নিয়ে নিলে।
না না কিন্তু তোমার কাছে তো ছিল এখন আমি নাহলে এখন নিলাম
And he has also filed an application for substitution, setting aside abatement.
So let that application be disposed of.
No, I have to file. Let me file the Bhogalandama first, then I will.
Yes.
I have to
the
continue.
matter with
Learned advocates for the
হ্যাঁ ভোকানোর না দেয় আর কি
আজকে যাবো তো আজকে তো
learned advocates for the parties are present.
Tomorrow.
On the prayer of learned advocates, the matter stands adjourned. Let this matter appear tomorrow. Whatever it is, the matter will remain. 4/8/2026. কটায় 10:30 না 12টায়?
Application should be filed. Setting aside abatement.
আরে জজ সাহেব একসঙ্গেই করে দেবেন বলছে
Contest করতে হবে 1400 পড়ে যায়
ধরুন না কন্টেস্ট who told you
Okay, 4/8/2026. Under the heading application. Tomorrow applications will be taken up, so let the application be disposed of.
at the same time it will be hard mind
তারা পড়তে হবে তো নাকি হবে আমরা ধরিয়ে দিলে পড়বো পড়া হয়ে গেল নাকি হ্যাঁ
একটা অ্যাপ্লিকেশন আছে সাবস্টিটিউশন আছে yes
number 2.
As per the respondent, my lord, in this matter, my lord, I have filed one cross objection. Not that, my lord, let it be kept tagged with the record.
Where file করবো?
Court number. Court of the থাকবে
Yes, you are for the appellant. The cross objection is also filed.
Yes, my lord. Cross objection, that is not on record, my lord.
It's incorporated in the paper book, cross objection.
After filing the paper book, my lord, cross objection is being filed, my lord. Why filing, my lord? The filing is about within time.
Yes, what are the grounds of challenge?
Only in respect of income. My learned challenge is only in respect of monthly income, and my challenge is, my lord, towards, my lord, deductions. Deduction towards, my lord, personal living expenses. Let the court may be treated on days list, my lord, and kindly proceed with the, my lord, hearing of the matter.
493, FMAT, MB 493.
493.
This is your appeal.
My cross is, my lord, court 59 of 2026. Days list. Huh?
Okay, then let the case be adjourned. Let the court.
Matter appear tomorrow at 10:30. I have no clue.
Both of you come with your written notes and what should be calculation as per you. And you also give me your calculation. I shall.
Yes. My lord, here, my lord, there are 4 claimants. Father is one of the claimants.
Yes, you give that a short note and your calculation tomorrow.
Yes.
And you also give your calculation in your note. Why you want to, how do you justify? Yes.
I justified that there is a salary certificate that has been exhibited at exhibit 11.
Yes, learned advocates for the parties are present. hard learned advocates, let this matter appear for further hearing on 4/8/2026 at 10:30 a.m.
After application.
Yes, after application. It may be taken about 11 or 11:30 as time permits.
Let the matter will appear along with the court, COT.
Yes, let this matter appear along with COT
59 of 2026.
59 of 2026.
That I appear for the installment.
Yes, item 3.
I am for the applicant insurance company. 2 points are involved in the matter.
It is your appeal.
No,
My appeal.
we got an award from the tribunal. The awarded amount is 15 lakh.
Did you file any cross objection? Okay.
So, it requires, but
Fair and recovery, that will be 2 points is involved. One is quantum and another the offending vehicle, the driver of the offending vehicle has no driving license at that time of.
Is there any findings by the trial judge that the driver did not have any driving license?
Yes, ma'am.
Let me see that findings.
The learned tribunal accept that point, but no explanation has been given why pay and recovery will not be granted.
Let me see the order.
Page 21, this is the findings of the learned tribunal. Page 21, last paragraph. Page 21, last paragraph. The learned advocate for the opposite party number 2 challenge the validity of the driving license of the driver of the offending vehicle. The exhibit B reveals that the validity gap period as mentioned in the said document does not include the period on which the accident took place. But no explanation has been given that just having that accept this. Generally, you will also kindly see supplementary affidavit, supplementary paper book.
Supplementary paper book.
Page 5.
এই সাপ্লিমেন্টারি পেপার বইটা দিন দেখুন। এটাই কি? ও
Page 5.
Page 5. Page 4.
Page 5, my lord.
Page 5.
No, my lord. No parcel, my lord, has come to depose. And my lord, the oral documents, my lord.
The public document, you also can see page 5, my lord. The order dated 23rd, dated 18/11.
Okay, page 5, yes.
Page 5, my lord.
Today is fixed.
Today date fixed for evidence. Both sides files Hajira through their learned advocate, Udle Sukanto Chatterjee, staff of PVD, Salt Lake Unit, is present on behalf of the opposite party number 2, along with the extract of driving license bearing number such and such in respect of Nosibul Mondol as per summons issued by this court, and the witness is authorized by ARTO Public Vehicles Department, Salt Lake Unit, Kolkata 19-1. By filing petition, learned lawyer for the opposite party number 2 paid for exhibiting the aforesaid license as it is a public document. Learned lawyer of the claimant does not raise any objection and tests in the same twin of learned lawyer of the opposite party number 2. Since the documents are public documents, hence the prayer is considered and allowed.
Okay, let me see the seizure list.
Then, your
License number is mentioned, but which authority issued that license?
But
It
you
will be
know-
applicable, it will be available from the seizure list.
No, here also can see page 4, my lord.
Page
extract of here, the driving license, my lord, page 4, my lord.
Page C, page C.
Page 4.
My lordship, before that, page C, your lordship kindly.
Page 4, yes.
4, my lord. Your lordship, second paragraph, validity gap theory, if any. Second paragraph, my lord.
Page 4,
Page 4.
yes.
My lord, accident in the year of 2018. But my lord, that validity was
No, so far the license of this person is concerned, it is genuine. It is not fake.
But that period was not.
Is it issued in the name of this person, driver? Okay. Now the question is, so far the driver is concerned, charge sheet was submitted against this driver.
Yes, my lord.
This is Nasibul Mondal. Okay. Now,
Clearly covering, my lord.
no, Nasibul Mondal, this is the driver of the offending vehicle. So his license shows that the accident took place on
Accident was 18. In the year of 18.
13 September
okay, accident
18.
took place
13 September 2018.
13 September
2018.
2018. And at that point of time, it was not valid.
Not valid, valid. You also can see this chart, my lord, the extract of the
My lord, before that, your lordship kindly see page C. The the validity details. Page C, with middle portion.
13?
My lord, page 3 of my supplementary paper book. Non-transport, my lord, validity 29/8/2011 to 28/8/2031, and transport 16 October 2020 to 15/10/2025. It is, my lord, within the accident.
That is, you see, 16/8, endorsement date is 16/8/2000, 16/10/2017.
To 15/10/2025.
Which column you are reading? Page?
Column is validity details, middle portion.
Yes, validity details. That is page 3.
Page C. Non-transport is 29 August 2011 to 28 August 2031, and transport is 16/10/2020 to 15/10/2025.
So the validity of transport vehicle, you see,
Both
one is
transport, non-transport are within the accident period. Accident took place 2018.
13/9/2018.
Yes.
Okay, and column, which column?
Which?
13/9/2018.
Transport vehicle, that was transport vehicle.
In the claim application, the accident.
Yes, 13/9/2018. Now, so far transport vehicle is concerned, you see, renewal of driving license, one is 15/10/2025.
Yes. 2020 to 2000, it is renewed period. And my lord, non-transport. Because
transport vehicle.
Because my lord, the person who was driving the vehicle is a non-transport. My lord, he was carrying the my lord company's water bottle and beverage. Non-transport.
So this is the driving license.
Vehicle is a offending.
Where is the registration number of the offending vehicle?
Yes.
Let us see that.
Yes. Your lordship, kindly see offending vehicle.
Page.
My lord, your lordship, kindly see the page 28 to 33 FIR.
28, yes. No, registration certificate of the vehicle.
Registration, yes. RC book is my lord, page 46.
It's the transport vehicle, my lord.
Registration number.
WB04E6699.
Bus.
Bus, yes.
Transport vehicle. Bus is a transport vehicle, my lord.
So let us come to these particulars of the license. That is, so in 2010, it was additional endorsement. Yes, from which category, which column we can conclude that during that period that 13/9/2018 does not fall within that period. 13/9/2018.
My lord, renewal. My lord, it was from my lord.
So we have to come from the bottom of this page, page 3.
Bottom of the page 3 and 4.
Bottom.
Page 3, my lord, bottom, your lordship kindly see.
19/10/2010.
10.
Yes, my lord.
10 to
And endorsement date 16/4/2012.
yes. Thereafter it was renewed.
Then 28/8/2017.
Yes. 28, your lordship kindly see column number 5, 28 August 2031. And
Column number 5.
Column number 5. And my lord, 28, it was renewed from 28/8/2017 to 28 August 2031.
No, but it says that TR is transport. TR is transport. Right hand is TR.
Renewal of driving license.
So this was under which route? Salt Lake.
No, my lord, the accident is the my lord, accident took place is Pashkura district, Purbo Mendapur, Purbo Itra.
RTO office is Salt.
So, my lord, the Golabari PS case number, that is in my lord.
You see, license number varies also. There are 2 license number. So this license number, the license number varies. So this license, that is page 46, it was valid.
Page 46 of paper.
Valid up to 11/6/2015. This was the certificate license which was seized.
Page 46 is the my lord, registration certificate.
Oh, registration certificate. Driving license which is seized. Anyway, that is, let us see the seizure list.
Seizure list, my lord, your lordship kindly see page 42 to 44. My lord, column number 8. PL number so in the name of Nasibul Mondol, son of so.
So Nasibul Mondol is there.
Yes.
So from this chart, WB,
It was valid up to 28 August 2031.
It is transport vehicle, Malad. Transport vehicle, not
Yes,
valid.
transport
On
valid.
transport vehicle T valid up to 28/8/2020.
31.
So he was permitted to drive.
That's for non-transport vehicle.
No, 28/8/2031, that is non-transport vehicle. But transport T valid up to 28/8/2020.
During the period of accident, they are not valid.
Now, let us see with regard to this license number WB01. What did this authority produce? Which license? The authority's deposition. Let us see.
No deposition.
How will this be exhibited without OP?
Yes, that is so.
Yes, well, that's why we also.
Let us see.
Submission is that this is public document, so let it be marked as exhibit exhibit AB.
No, just let me see. I think yes, OP number 2, yes.
OP number 2 is eyewitness. OP, there is no OP. PW2 is eyewitness.
Question is, here the license number is WB01 20030826820. And let us see the exhibit of the license which you have relied upon. I will 012003082680. Yes. As per the police authority, it is valid till 28/8/2020.
Thereafter, Malad, it was renewed. Malad, that page C, 16/10/2020 to Malad
28/8/2020. Yes.
to 15/10/2025. And the accident.
No. 28/8/2020. That is the last page. Valid up to 28/8/2020.
Yes.
The last. The last column.
Yes, the last
Transport. 28/8. Issue of driving license. 28/8/2020.
An accident took place 2018. What the count Malad taken that the driver had no drive.
No. You see, as per the seizure list, the police authority has stated that transport T valid up to 28/8/2020. Now you tally this with page 4. Page 4, you just tally this. Page 4, validity up to, you see, both NT and TR. So for TR is transport, you come to the last column. That is 28/8/2020. Probably thereafter it is not renewed. So let me see.
2000 EBT.
Now whether
Last year is 28/5/6/2020 to 16/10/2020.
No,
accident happened in the 18.
no, which column you are saying? You come to page 4, last one.
Column 3.
Page 4?
Column 3.
Point 3. Three is no. You see, so far you see this validity, this permit was issued. Yes, you see, last endorsed on 16 October 2020. But just below that, validity gap period. When was the validity gap period? Suppose 19/10/2010 to 29/8/2011. 19/10/2010, 29/8/2011. Then transport validity gap. So this period it was not valid. 28/8/2020 to 16/10/2020. So the accident took place not during the gap period, but during the validity period. Yes, did you challenge the quantum? Quantum, how much was awarded?
Tribunal, my lord.
Yes, yes.
No,
No.
My lord, 4,000.
In the grounds, he has challenged entire thing. He has not confined itself. Yes, how much was awarded?
15 lakh 91,000.
Actually, my lord, he claimed that he used to earn rupees 12,000 per month. But my lord, tribunal accepted his 26 days and accepted to 10,400.
How much?
10,400.
10,400.
But my yes, here also can see the deposition of PW1. There's 13. There's 13, my lord.
I do not have any documents to show that I.
I do not have any document to
Oh,
show
that Andrews.
Next, then my lord, you also can see PW3.
PW?
There's 16.
KW3.
There's 16.
Yes. Salary certificate.
Salary certificate, yes, my lord. Here also can see that I have come before this court being summoned to depose as witness. I have been authorized by the director of the Sorry, Bottling and Beverage Private Limited. This is the said authorization letter in original. The authorization letter is marked at Exhibit 7. Sukanto Kaur was an employee of our company. I have brought the OH certificate of, and he was day labor. The original salary certificate is tendered before this witness. This is the original salary certificate signed by our director, Rajiv Ranjan Singh. I know the signature of him. The signature, this original salary certificate is marked to Exhibit 8, cross-examination. I have been summoned to appear before this court. I am an officer of the company for 6 years, last 6 years. I do not have any identity card issued by the company. The company has trade license for all business. It carries out, but I have not brought the same today. No register is mentioned for the daily laborer in our company. His name is not mentioning the master payroll of the company. But he claimed that he is a day laborer of such company, but no register is mentioned for daily laborer in our company. His name
So Rane trial judge accepted how much?
Accepted
trial judge accepted
10,400. That is, my lord.
Considering the holidays.
26 days into 400. What's wrong, my lord, the tribunal committee?
10,400.
400 into 26.
And another thing is this, regarding general damages that is rightly awarded, 70,000.
70,000, it should, if I file a cross appeal, keeping my lord.
And interest awarded?
6%.
6%.
So no grounds, my lord, at all.
No grounds.
My lord, the grounds are twofold. First is the regarding income. Income, my lord, that
1/4 deduction, it is accepted.
1/4 because the claimants are 5. My lord,
father is a claimant. Father is claimant. He is not dependent. And
that ground has not taken in the memorandum appeal.
Only quantum, the
Only.
income.
My lord, the landed tribunal, even if my lord father is not, my lord, dependent or not legally are, my lord, there are, my lord, wife, son, daughter, and mother. 4 members. That the Sarala Verma or the, my lord, the pronunciation says it should be 4 members, it should be 1/4. Landed tribunal, my lord, acted on the basis of 1/4. How, my lord?
The father died. Mr. Bonik submits that the respondent of 5 is the father of the deceased who expired.
Already father died.
Now, the monthly income was claimed to be 12,000, but the learned trial judge considered as rupees 10,400, which according to you is excessive. Compensation awarded is excessive.
My lord, 400.
So what should be the reasonable compensation according to you?
Well, actually, income may be
5,000.
But he failed to prove that he is a deliverer. His name has not been in the payroll.
No, you see, suppose nobody has come to depose. In that case, the Minimum Wages Act will apply. But here he has taken the initiative to examine the witness.
My lord, one of the representative of the employer and the my lord, kindly see the salary certificate exhibit 8
page
52. Corona.
It's 57.
57.
Yes. Oh, it's a limited company.
Yes.
Hold on.
57. Your lordship, kindly see. This is certified that the Subroto.
Okay, 400 per day.
400 per day.
Oh, he was a day labor. That means for 3 years, 12,000. But considering the holidays,
26 days, my lord, and a time. There is no wrong, my lord.
yes, take down. Learned advocates
And
for the
only thing,
parties
my lord, the father died.
are
My lord,
present. Hard learned advocates for the parties. The appellant before this court was an opposite party in a case under section 166 of the Motor Vehicles Act 1988 and is aggrieved by the judgment and award dated 9
Submission করেছে order কেটে নেই।
judgment and award dated 12 September 2022 passed by learned additional district judge first track second court Howrah in MSC case number 258 of 2018. Stop. The case of the claimants before the learned trial court may be
my lord,
some.
I am appearing for the respondent number 124. 5 already right.
To substitution carried out.
No. Substitution is not required. Already, my lord, kindly see the order dated 25th April 2024. That
The name is deleted. Respondent number 5's name is deleted.
1 to 4 are entitled to get.
5's name is deleted. Achha.
No, your lordship.
1 to 4.
Deleted হবে legal years already in record.
ঠিক আছে একটা চাকরি থেকে
1 to 4, my lord.
No, I have to delete the name then. What is that order?
Order is, my lord, your lordship, kindly see the 25th April 2024.
देखिए ऑर्डरটা দেখি 25th April
Order কিছু নেই। The order is
Only submission. My lord, since I filed the.
You did not file any application. Do you have the death certificate? So on what basis? This
All right, your lordship, kindly.
Let me pass the usual order. You file
ঠিক আছে।
necessary application.
No, my lord.
ঠিক আছে
My lord, but it was but just now, my lord, had talked. My son had talked with the learned advocate. He is alive.
Yes.
The father is alive.
Okay. The case of the claimant's appellant before the learned trial court may be summed up thus. Number তলায় লিখুন on 13/9/2018 at about 9:30 hours, the victim, namely Subroto Kaur, was walking at the extreme left side of the road at Kolkata bus stand at the material time. Stop. At the material time, one bus bearing number WB -04 capital E stroke 6699, which was proceeding rashly and negligently, suddenly dashed the victim with great force. Stop. As a result, he sustained severe fatal injuries and it caused his death. Stop. Rash and negligent driving on the part of the driver of the offending vehicle bearing number WB04 capital E stroke 6699 was the cause of the pathetic accident. Stop. The accident could have been avoided if there was prudent driving. Stop. The victim, deceased, was an active man. Stop. He was the sole breadwinner of his family. Pursuant to filing of this case, notice was issued upon the opposite parties. Stop. Opposite party, vehicle owner, did not contest the case. Stop. However, opposite party, National Insurance Company Limited, contested the case by filing written statement. Stop. Issues were framed and evidence was adduced. Learned trial judge, upon considering the evidence adduced and upon hearing the learned advocates, was pleased to dispose of the claim case by observing and directing as follows. Page 23, folded page. The learned advocate, the appellant, being aggrieved by the judgment and award passed by the learned trial judge, has come up with the instant appeal. Stop. Heard learned advocate for the appellant and learned advocate for the respondent's claimants. Stop. Peruse the evidence adduced and materials on record. Stop. Learned advocate for the appellant submits that the driver of the offending vehicle did not hold any valid driving license. Thus, the insurance company should have been either absolved of the liability or should have been granted the right to recover from the vehicle owner after making the payment. Now, learned advocate also submits that the learned trial judge, without any document, considered the income of the victim as rupees 10,400. Stop. It is also submitted that the compensation awarded is excessive. Mr. Bonik, on behalf of the respondent's claimant, submits that the driver of the offending vehicle was holding a valid driving license. Stop. Learned advocate further submits that the claimants examined the employer of the victim. Thus, the learned trial judge rightly proceeded on the basis of the monthly income of rupees 10,400. Learned advocate also submits that the compensation awarded should not be interfered with. Stop. With regard to the first submission of the learned advocate for the appellant, that the driver of the offending vehicle was not holding valid driving license, attention is drawn to the extracts of the driving license issued by the transport authorities. It appears from the extract of driving license of the driver of the offending vehicle, Nasibul Mondol, that the driving license was first issued on 28th August 2003. Stop. Thereafter, the said driving license was renewed from time to time. Stop. It is the statement made by the transport authorities that the said license was not valid from 19/10/2010 to 29/8/2011 with regard to non-transport vehicle. Stop. With regard to transport vehicle, the said license was not valid from 19/10/2010 to 29/8/2011 and from 16/10/2020, and from 28/8/2020 till 16/10/2020. In the seizure list, the police authority mentioned that the said license with regard to transport vehicle was valid till 28/8/2020. Stop. As the accident took place on 13/9/2018, the said driving license of the driver of the offending vehicle was covered by a valid driving license. Stop. Thus, the plea of the insurance company cannot be sustained. Stop. With regard to the submission of the learned advocate that the learned trial judge considered rupees 10,400 as monthly income of the victim and the compensation awarded is excessive, this court is of the view that as the claimants have examined the employer of the victim and the victim is not an individual but a limited company, and from the evidence of PW3, the employer of the victim, nothing has come out in the cross-examination that the victim was an employee of Page 6.
1/6.
1?
1/6.
Yes, that the victim was an employee of Sharveshwari Bottling and Beverage Private Limited. This court does not find any error with regard to the decision of the learned trial judge in considering the monthly income as rupees 10,400. Stop. Thus, with regard to the arithmetical calculation of the compensation, this court does not find any error of the learned trial judge. Stop. However, as courts are empowered to award just and reasonable compensation, this court is of the view that compensation of 15 lakh is just an
91,000.
yes.
And only 70,000 general liability.
Okay.
It should
15
be-
lakh. I have considered the whole. I am of the opinion 15 lakh will serve your purpose.
No, man, 15 lakh, 91,000 you lost
Yes.
deducted.
In some cases, 1,50,000 is also deducted.
But 91,000, kindly consider.
No, 15 lakh is just and reasonable.
15 lakh 50,000, kindly consider.
Thus,
Well, 15 lakh 91,000
hence this appeal, FMA 689 of 2024 stands disposed. The judgment and award dated 9/1/2024, passed by learned Additional District Judge, First Track, Second Court, Howrah, in MSc case number 258 of 2018, stands modified to the extent that the claimants respondents are entitled to compensation of rupees 15 lakh. Stop. The appellant insurance company shall deposit rupees 15 lakh along with interest at the rate of 6% per annum from the date of filing claim case till today.
Kindly mention the date of filing is 17/6/2022.
Date of filing, that is
17/6/2022.
17/6/2022 till today. Before the Registrar General, High Court, Calcutta. Such deposit shall be made within 8 weeks from the date of communication of this order. The respondents' claimants will be entitled to withdraw the compensation upon compliance of in the event the compensation awarded by the trial court is already deposited, no further deposit be made. The claimants respondents will be entitled to withdraw the compensation upon compliance of necessary formalities. Balance amount, if any, along with accrued interest, be returned to the appellant insurance company.
One thing, my lord, that
The rest of the amount.
my lord, the appellant insurance company has deposited the awarded amount in the year 2024. Now your lordship is disposing the appeal in 2026. My lord, that time, my lord, whether it was invested or not, I do not know. But
I made it, if accrued interest, if any. Anyway, balance amount he will be entitled to withdraw and accrued interest, if any.
And my lord, one thing, Lale Registrar General is directed to disburse.
To allow to withdraw the rest of the amount.
I have recorded that.
Okay.
Item number 4. Item number
এটা রেখে দিন এই যে এটা
for that.
you are for the appellant.
Paying on Southeastern Railway.
You are for
Southeastern Railway. Respondent.
My lord, this appeal has come, my lord, against the challenging the order of dismissal by the Railway Claims Tribunal. Passed by the Railway Claims Tribunal. My lord, here, Baptupal, he was traveling. Paper book nahi?
Number 5.
Huh?
Number 65.
হ্যাঁ কেটে ঠিক করে দিচ্ছি
সেটা কি নাম্বার?
1105 হ্যাঁ হ্যাঁ
65. ভুল হয়েছে
yes.
Now, my lord, this Baptupal, he was traveling from Dashnagar to Andul. He went to Andul, there, Dashnagar, thereafter he was returning to Andul.
From Andul to Dashnagar and back.
Yes. Because at the time of the accident, he was traveling from Dashnagar to Andul. Now, my lord, untoward incident happened due to heavy gathering, heavy crowd, my lord, he fell down from the running train and thereafter he died. Now, my lord, in order to prove this case, my lord, we have examined the claimant. Claimant means the wife of the deceased, Anamika Haldar. Thereafter, my lord, this person was traveling along with his own brother, Pintu Pal. And he was both eyewitness and also he was accompanying the deceased. So, my lord, this Pintu Pal was examined as eyewitness, and my lord, thereafter deposition, defendant witness was examined, the loco pilot adduced evidence, and my lord, CW2, Prakash Choube, RPF, he also adduced evidence, and deposition respondent number CW1 is Sri Obhijit Shomadar, OC Shalimar Jia. Now, my lord, Baptupal was a bona fide passenger. He was traveling with a ticket. That ticket, my lord, is marked as exhibit, my lord, according to exhibit 7, sorry, page number 117, 117 of the paper book, my lord. One seven of the paper book, my lord. This ticket shows that it was purchased on 9/4/2019 at 17:47 hours. That means after 5 o'clock, 5 p.m., 5:47 p.m. This was, and my lord, the accident happened. And the accident happened
9/4/2019 at 5:47 hours.
No, that is the purchasing ticket. Ticket was purchased at 5:47.
That is from Dashnagar.
And accident happened, my lord, at 20:10 hours. 20:10 hours. When after purchasing the ticket, thereafter he boarded the train after some time. And 20:10 hours.
That means 8:10.
8:10. 5. At 5 o'clock, it was purchased, my lord. And at 8:10 hours, the accident happened. It is, my lord, page number 4, column number 6B. Answering portion of column number 6B. Claim application, my lord. Page number 4.
Yeah. Column number 6B.
6B. Page number 4, column number 6B. That on 9/4/2019, Baptupal along with his brother Pintu Pal and his friend Somoresh Pal was traveling from Dashnagar to Andul by train. It was about 20:10 hours. He fell down from the said running train due to overcrowded pressure
and sudden jerk in between kilometer number 9/13 to 9/15 upline at the outside of the track. As a result, he died on spot. He was a bona fide passenger of the said running train. It was a stormy day and the train was running at late. Now, my lord, we filed the claim application. Thereafter, evidence was taken, and my lord, thereafter the learned tribunal was pleased to dismiss the case, disbelieving that it was an untoward incident.
Page.
My lord, it is judgment, my lord. Page number 86.
Yes.
86, my lord, judgment starts, and it is my lord, the big judgment. Considering the page number 103. Page number 103, my lord. 103. (103) 7.11 in the bottom portion, my lord.
Yes.
Therefore, it is clear that the applicant could not adduce cogent evidence to prove that the deceased was having a valid ticket and death of the deceased was due to fall from the train. Considering the factual elements coming out from the discussion, these issues are held against the applicant by holding that it is amply proved that the applicants could not establish that he was a bona fide passenger, and the applicant could not also prove that the death of the deceased was caused due to fall from the train. Hence, it cannot be stated as an untoward incident as defined under section 123(c)(2) of the Railways Act 1989 involving the victim. In view of the foregoing, next page, my lord. Next page. In view of the foregoing, this issue is not required for the further consideration. The applicants have failed to prove issues number 1 and 2. Hence, they are not entitled to get any relief as prayed for. The case is dismissed. Now, my lord, I have already stated, my lord, that, my lord, we have examined the claimant, the eyewitness, and they.
The claimant was examined as PW1.
Claimant was examined as PW1, my lord, and eyewitness was examined as PW2. And, my lord, now the railway authority adduced evidence, and, my lord, that was CW1 and CW1, two CW1s and CW2. Now, my lord, I am coming to the evidence of PW1 eyewitness. Sorry, PW2 eyewitness. Eyewitness. Page number 68, my lord. Page number 68. Let's start with page 68. I, Pintu Pal, son of Tapan Pal, aged about 36 years, by faith Hindu, by profession service, residing at village and PO Jobagram, PS Mongol Court, district Bardhaman, pin code 713143, West Bengal, do hereby solemnly affirm and declare as follows: that on 9/4/2019 at evening, I, along with my elder brother Baptu Pal and my friend Samoresh Pal, went to visit the house of Shobhik Mondol at Dasnagar, and as he had been suffering from illness since 1 week. Baptu Pal left his house a bit earlier to Dasnagar RS. He purchased his ticket about 17:47 hours. After a few minutes, I, along with Samoresh Pal, left Shobhik's house and reached at Dasnagar RS railway station. We purchased the railway ticket from Dasnagar railway station to Andul railway station separately. At about 18 hours, I, along with my elder brother Baptu Pal and Samoresh Pal, boarded on up Howrah Mecheda local train for the journey to Andul railway station in the same compartment. I, along with my friend Samarespal, went inside the compartment, but my elder brother could not able to enter inside the compartment as the train was overcrowded. While the said train was running in between Satragachi railway station to Maurigram railway station, suddenly we received information from other co-passengers of the train that one person fell down from the running train due to overcrowded pressure and sudden jerk near at 12 number railgate, and at the time of incident at about 18:22 hours. Then we immediately came at the door of the compartment and we started searching my brother, but we could not trace him out. We immediately got down from the train at Maurigram railway station. We reached at the accident place by Toto rickshaw and found him lying dead. We stood there to guard the dead body of my brother and also informed the incident to my friend and family members. The GRP police officer along with other persons came after. A long time, the police officer also inquired the matter and we told him in details about the accident. The police officer also searched the dead body of my brother and found voter card, Aadhaar card, PAN card and one railway ticket. Railway ticket was recovered. We also signed the documents prepared by police that the direction of RPF officer, I signed the statement prepared on 1/11/2019. But I had not read the said statement and the contents of the statement written by RPF personnel were not read over to me. I am absolutely denying the time of returning back at platform Dasnagar railway station from our friend's house, as well as the visiting time as the time of staying at my friend's are also false. Now, my next page 70. Page 70. I have tendered my affidavit in chief to court. To the court. He was not cross-examined by railway authority, my lord. The learned court himself took the evidence. I am engaged as a welding job. The deceased Baptupal was my elder brother. I, along with the deceased and my friend Samarespal, were going to Andul from Dasnagar to buy clothes for ourselves. Today, I have filed my affidavit and I also signed it. In the train compartment, I and Samarespal were inside the compartment, which was 10 to 12 feet away from the gate. Due to overcrowding, it was not possible for us to see the gate from the place where I was standing. It is incorrect that there was no rush in the compartment. I requested my deceased brother to come inside the compartment, but he did not come in the inner part of the compartment. Some co-passengers of the train shouted that somebody had fallen down. I cannot say that the incident could have been avoided if my brother was not traveling on the footboard of the compartment. I had purchased my ticket. I purchased the ticket. It is correct that on the day I was carrying a mobile phone and that mobile phone had an internet connection. I have no proof like a ticket, Google location or mobile tower location to prove that I was traveling on the train with my deceased brother that day. I have no documentary evidence to show that on the date of the incident I was traveling with my brother. We had our individual tickets, not a joint ticket. The police returned the voter card, PAN card, Aadhaar card of my deceased brother to me, but I did not sign any Jimmanama or any authority while taking over these documents. Self-stated that his ticket was not returned to me. It is incorrect that I have given false evidence to help my sister-in-law to get compensation from the railways. I have given a statement to the RPF and I put my signature on the RPF report, but the concerned RPF did not explain to me the contents of my statement recorded by him, but I did not lodge any complaint that RPF took my statement forcefully and without explaining the contents even after 5 years. My working place was at Satragachi. On the date of the incident, I went to Dasnagar to see my ailing friend Souvik Mondol from Dasnagar. I purchased my ticket. My deceased brother came to Dasnagar station at about 17:47 hours. We boarded the train at 18:10 hours. I did not see my brother falling down from the train. I did not the alarm chain. After the incident, I deboarded at Maurigram at 18:24 hours. Then by a Toto, I reached the place of occurrence within 20 minutes. By 18:45 or
So the
so,
place of accident was between which two stations?
Dashnagar and Andul.
Dashnagar Andul. This person got down at Morigram.
Morigram. And also went to the spot. After receiving this information, he got down at Morigram and thereafter returned to the place. I do not know whether 20 minutes or so, Samoresh Pal also went to the spot with me. I do not know whether the GRPs called an advocate on GRPs. It is correct that I was told by GRP, in case we do not file any claim application, we will not get compensation. It is correct that the signature of my sister-in-law was taken by GRP for filing claim case. It is incorrect that on my behalf, my sister-in-law signed and blank GRP papers. It is correct that I did not inform the incident to my sister-in-law till next morning. It is incorrect that my sister-in-law was suspecting me for death of my brother. It is incorrect that I told my sister-in-law that in case I do not adduce evidence, she will not get any claim. It is incorrect that I was advised by the advocate of GRP to become an eyewitness in the case of a co-passenger. I only got the Aadhaar card, PAN card and voter card of my deceased brother. Nothing else. I do not remember whether any receipt was taken from me by the GRP while giving these articles. My deceased brother was not carrying any money. He was also engaged in a welding job. He was married. It is correct that he was going to buy clothes from Andul, though he was not carrying any money. Self-stated that he was to bear the costs of the garments to be purchased by the brother. I signed the inquest report and seizure list in the GRP Satragachi. I did not sign the inquest and seizure at the spot. My statement was recorded in the inquest report by GRP. I do not know the English. I cannot say what was written in the inquest report. I signed the inquest report and seizure list at the night of the very day and the incident in GRP police station. I did not sign these documents at the spot. It is incorrect that I am giving false evidence to help my sister-in-law to get compensation from the railway. It is incorrect that it was not traveling with my brother by any train at the time of the incident. So one thing is that he stated that he was not signed the documents
in the spot, but at the police station. That is the question.
Yes, that is the question. So he fell down between Satragachi and Morigram. My lord, it is stated in page number 68, line number.
Oh, between Satragachi and Morigram.
Satragachi and Morigram. The line number, page number 68, para 1, and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. While the said train running in between Satragachi to Morigram, suddenly we received information from other passengers of the train that one person fell down from the running train. So from Satragachi and Morigram, he fell down. Huh? Now, my lord, I am coming to, my lord, the railway ticket, my lord, I have already shown your lordship, page number 117, that it was purchased on 9/4/2019 at 17:47 hours. Now, my lord, the next, that is exhibit A8, certified true copy of railway memo, page number 118.
Yes.
Railway memo, removal of dead body. This is 9/4/2019, 20:10 hours. As per information by ADL SMS Sri Mujumdar, that as per LP of YS1 unknown male dead body is lying outside, my lord, outside. This is the thing, my lord. I am pointing out, my lord, that dead body was lying outside the track at kilometer 9/17, aged about 40 years. So, PM, please arrange the removal of the same dead body as early as possible. You are writing, the railway authority is writing to the OC GRP, Southeastern Railway. Now, my lord, in the next page, my lord, It is this Caesar list, page number 119. The witnesses are Pintu Pal. He has already stated that in his evidence, my lord, AW2, sorry. He has stated that he signed the Caesar list and inquest report. Pintu Pal. And Somoros Pal is also here. He has also stated that the Somoros Pal was trained and he was also traveling with him. Now, my lord, date and time of seizure: 9/4/2019, 21:55 hours. Place of seizure: beside railway track at kilometer post such and such, 15 upline. So beside railway track, my lord, not inside railway track.
So what was recovered from him? Photocopies of voter ID card,
my lord,
Aadhaar card.
in respect, my lord, here found from the pant pocket, number 3, my lord, 1, 2, 3 from the top.
No, page 119.
119 from the top, my lord. 1, 2, and 3. Third line. 1, 2, 3. It is written. The figure, my lord, 3.
One original railway ticket.
From Caesar list found from the pant pocket of the deceased, namely Baptu Pal, male, aged about 33 years, son of such and such, Jobagram, PS, district such and such.
But no money was found.
No money was found. Now, my lord, number 5, article seized: photocopy of voter card, Aadhaar card, PAN card in the name
now,
of.
regarding, you see, did PW2 say that railway ticket was found from his possession? Because PW2 was not present when seizure took place.
My lord, Caesar, at the time of Caesar, PW2 was present.
Let us see that PW2.
Yes. PW2, my lord. Deposition of PW2, page 68. Yes. Train was running, suddenly we received.
So when this Caesar list is prepared on 9/4/2019.
Yes, same day.
Yes.
From Railgate at the time of the incident. The matter, and we told him the details about the accident. The police officer also searched the dead body of my brother and found voter card, PAN card, railway ticket. We also signed the documents prepared by police. Page number 69, first para, my lord. Page number 69, first para. The police officer also inquired the matter and we told him in details about the accident. The police officer also searched the dead body of my brother and found voter card, Aadhaar card, PAN card and one railway ticket. We also signed the documents prepared by police. We means that Somoresh and the person, the friend who was traveling, that the direction of the RPF officer, I signed the statements prepared on 119, but I had did not read the statements. Now, my lord, Caesar list, page 119, it shows that the ticket was seized, my lord. Now, and it was also signed. It was signed by Pintu Pal. This Caesar list was signed by, my lord, Pintu Pal and Somoresh Pal, both.
Anyway, but they said that they were not present. They did not sign it on the spot, but in police station.
But afterwards, yes, they stated it. They stated the true thing, my lord, honestly, maintaining their honesty. Now, my lord, thereafter Caesar list, there is dead body, true copy, dead body challan, and thereafter, my lord, A11, 121, my lord, true copy of investigation report, Surathal report, that is inquest report, page 121. Kharagpur GRP, Shalimar GRP at 20:36 hours, 21:25 hours, and 22:25 hours. Investigation closed. Now, my lord, opinion and witness. Opinion of witnesses as a cause of death. Here also, my lord, your lordship will find you got t-shirt, underwear, and a black color jeans pant. Whole dead body. With the help of the DOMS, the photocopy of voter card, voter ID card, Aadhaar card, and PAN card in the name of Baptu Pal, aged about 33 years, son of Tapun Pal, and one railway ticket, my lord. This inquest report, my lord, says one railway ticket, white numbers, such and such. The same, my lord. That page number 117. So from Dashnagar to Andul railway station. Purchased at 17:47 hours, and value of the ticket was ₹5. And according to the witnesses, that is relatives traveling with him in the same train, stated that due to heavy gathering, he fell the
running train.
Fallen from running train with which resulted to death. I agree to the witnesses' opinion. So, my lord, he fell down from the train. It is clear from the inquest report, and my lord, ticket was recovered. Along with his, according to them, according to the inquest report, ticket was recovered. So, my lord, he was a bona fide passenger, definitely. He was lying, next page, my lord, he was lying in the
next page.
In the sleep position, right hand was in the upward direction, and the head was in straight direction near the leg. Eye was slightly open. Teeth were visible. Hair was black color. His height was 5 and 6 inches with normal figure and fair skin, fair skin. And injuries, there is a 6 inches deep cut in the part of the neck, upper part of the neck, and the back side of the upper ear. And left jaw was fractured. Left jaw was fractured. Falling from the train, my left jaw was fractured completely. There was 8 inches cut in the head. Right leg ankle was separated and was 4-inch cut in the left legs. At the chin, both the ears and nose were bleeding. So, my lord, this proves that his body was recovered in such a manner that which clearly proves that he fell down from the train. Now, my lord, true copy of FIR. Police final report. My postmortem report is there, page number 124. 124 is postmortem report, my lord.
Yes, 174 report you have submitted.
What? Yes, my lord.
174 report.
What?
This is 123.
123, my lord. It is FIR. 123 is the FIR, my lord. This investigation report is the truthful means inquest report, my lord. Now 123 is the FIR, my lord. Officer in charge received written railway memo that started the Shalimar GSP on 9/4/2019, which is treated as FIR, and as per intimation by ADI SM Mojumdar that as per LP of 18409, one unknown male dead body is lying outside, my lord, outside the railway track, my lord. That at kilometer of aged above 40 years. So, my lord, the railway, the body was recovered. According to the FIR, body was recovered outside the railway track, my lord, that area. Postmortem report, my lord, it is written that death was due to effect of injuries, antemortem in nature. Now, my lord, this is the final report, page number 125.
Yes.
The fact of the case is in brief that after received railway memo issued by Ashim Kumar Das, Station Master, Satragachi, Southeastern Railway, Bhait Satragachi Police Station, Master Office, DF number such and such, our DL. This case has been registered and as endorsed by OC Shalimar PS, myself along with the Ajay Bauri of Satragachi GRP, including domes, rushed to the PO in kilometers such and such with sufficient light and lights and noticed.
A male corpse.
Yes, a male corpse aged about 33 years lying outside the railway track. I am saying, well, body was found outside the railway track, not inside. Outside the railway track. Accordingly, the present witnesses as well as the relatives of the deceased and all were present at the PO and identified the deceased, which is noted above. During inquiry of the locality, it could reveal that the witness and relatives' opinion traveling with him in the same train stated that due to the heavy gathering, he accidentally fallen from the running train at the time of journey from Dasnagar railway station to Andul railway station, which resulted to death. I checked the whole dead body with the help of domes and found photocopies of voter card, Aadhaar card, PAN card in the name of Babtu Pal, aged about 33 years, one original railway ticket vide Samba such and such from Dasnagar to Andul railway station, DOJ 9/4/2019, and value of ticket was ₹5, found from the pant pocket of the deceased. Next page, my lord, 126, which I seized properly in presence of witnesses, calm relatives, and also prepared inquiry report over the said male dead body and sent the said male dead body to Howrah Sodor Hospital morgue for
postmortem
PM
examination.
I received PM report on 483/9 dated 10/4/2019, which autopsy surgeon Dr. Chittoranjan Bhattacharya, medical officer, medical legal Howrah Division Hospital, passed opinion that the death was due to effect of injuries noted above, antemortem in nature. Till now, nobody made any complaint regarding any foul play behind the death of the deceased. Consulted with my superior officer as advised, I submit this final report to file the UD case, at present keeping the UD case with a view that the UD case may kindly be reopened if any would be detected regarding foul play behind the death of the deceased. Therefore,
any clue,
if true, if any true, if any clue, if any clue could be detected regarding foul play behind the death of the deceased. Therefore, I pay before your honor that the case day may kindly be filed. So, my lord, up to this, we have been able to copy a final police report. These are not important. So, certified copy of identity card of Om Prakash Choube, authorization letter of certified true copy of the extract of LOC. Now, my lord, I want to come to, my lord, the deposition of CW1 Manik Sengupta, page number 72. Page 72, man. Manik Senaputi. Manik Senaputi.
Yes.
My name is Manik Senaputi as proof of
CW1.
CW1. I am filing my office identity card. The copy of my office identity card is filed as witness marked exhibit C1, and the certified copy of extract of loco pilot dated C is marked as exhibit 2. Examination in court. Presently, I am posted as loco pilot at Kharagpur. On 9/4/2019, I was posted at Kharagpur as loco pilot. On that day, I was on duty driver of 18409. On that day, during my duty hours, after crossing Satragachi station, I suddenly saw a dead body lying by the side of the railway track, which was not earlier cautioned to me. The dead body was lying a little away from the railway track. After noticing the dead body, immediately I informed it to on-duty station master Andul over phone. I had also noted the fact in my driver's diary. So he noticed that the dead body was false, and he immediately informed. Now, my lord, page number 73, statement of Sri Obhijit Shomadar, stated on oath before the learned tribunal. In compliance with the order of the learned tribunal, today I have brought the original record and the same are kept to the file and will be returned to the concerned police station after pronouncement of the judgment. The case was not investigated by me as per memo issued by SM Satragachi, which is a part of the record that one unknown male dead body was found lying outside the track at kilometer 9/7. Normal page number 74. He was the Om Prakash Choube, SI RPF. CW2, CW3.
Page 74.
Page 74.
Yes.
Examination by the court.
Yes.
He was not examined by the railway authority. He was examined directly by the learned tribunal. The incident took place on 9/4/2019 on the day I was on duty ASI of RPF at Satragachi station. On that day at about 9 p.m., I received information from SM Satragachi about lying of a dead body beside the railway track. After getting information, I along with RPF Constable Rajiv Ranjan reached the spot. So they, my lord, reached at 9 p.m. after the inquest was done. After about 15-20 minutes, GRP personnel along with DOMS reached the spot. GRP reached the spot after me. I remained at the spot from 9 p.m. to 10:30 p.m. till removal of the dead body from the spot. Searching of the dead body was done in my presence by DOMS, and one Aadhaar card, PAN card were recovered from the possession of the dead body. Nothing else. No railway journey ticket was recovered from the possession of the dead body. My lord, the seizure list was prepared at 8 o'clock. And my lord, I made the entry in the concerned RPF daily diary. This paper bears my signature and I made entries in the paper in my own handwriting. The witness is shown the copy of statements of RPF, IO, RPF, copy annexed with the DRM report. This paper bears my signature. The RPF inspector recorded my statement. I did not put my signature in any GRP papers. Till the body was cleared from the spot, no known person of the deceased came and identified the body. When I reached the spot, the body was lying unidentified. The body was identified from the Aadhaar card recoverable from the pocket of the deceased. I have prepared the sketch map. This witness, my lord, stated that it was not recovered. Then, my lord, everything, other statements, those are false. Then, how is it possible? So, my lord, this person must have.
Either this witness has to be believed or the police witness has to be believed. So, what is the report of the DRM authority?
DRM authority.
DRM report.
DRM report. Page number 12.
Yes.
Verification of occurrence under section such and such as per নোটটা ভালো পড়া যাচ্ছে না এই রিপোর্টটা পড়া যাচ্ছে না
Okay, this was verification report.
Verification report, my lord. It is the beginning. Thereafter, there are other Southeastern Railway DRM report is there. It is, my lord, page number 12 to 64. 15. Lord, kindly come to page number 15, my lord.
Page 15.
15. On the above subject, it is to submit that the undersigned caused inquiry into the matter.
Page 15.
Page 15. That was the beginning, my lord. Right?
Yes.
From here it starts. It is to submit that the undersigned caused inquiry into the matter in detail, and following facts came in the light regarding inquiry. The claim is made by Anamika Haldar Pal and others dependents of the alleged death of her husband Pintu Pal on 9/4/2019 under reference referred letter such and such by Honorable CT Kolkata bench, and the claim compensation letter number such and such, which I furnished as follows. SRM ADL SRC D. As per SRM ADL D 411 that loco pilot of train number 18409 reported that one dead body was lying in the at kilometer 9/17. They could not observe that the gender due to speed. Matter reported to SMRC as per SM SRC D number such and such dated 9/4/2019 that the matter reported to OC GRPS SRC to arrange the removal of the dead body. Statement of SM ADL. During inquiry, I recorded the statement of Sri S. Mujumdar SM ADL, in which he stated that at about 1940 hours, loco pilot electric Sri Manik Senapati of train number A18409 informed over walkie-talkie that one dead body may lying in kilometer 9/17. Immediately, he reported the matter to the duty RRI public SRC and PF SM SRC as per ADL D number 411 for the further necessary action. Now, ticket verification, my lord. First of all, that then EO visited the DNR railway station, Dasnagar railway station, and met commercial supervisor of DSNR, Dasnagar railway station, for verification of the general ticket number 10615915, UTS number T02F CCD0DODE dated 9/4/2019, X Dasnagar to Andul, where CS Dasnagar, CS Ojha checked and verified the said ticket according to DSNR station record and issued a verification report about the same said ticket in this regard. Further, I undersigned verified the railway ticket from CCM Kolkata, which was shown by the applicant in his application, and found that the ticket was purchased at 17:47 hours from Dasnagar railway station, both copy enclosed. So ticket was definitely, my lord, it was verified that ticket was issued from the Dasnagar police station, Dasnagar railway station. P-Way SRC during inquiry, then EO visited to the P-Way SRC West office and inquired about the untoward incident dated 9/4/2008 kilometer 913 and 915, where he issued a track fit certificate, which he mentioned railway tracks of up main line between kilometer 913 to 915 was fit for normal passage of trains on 9/4/2019 under the jurisdiction, and these units copy and close. Statements of the duty loco pilot train number such and such. During inquiry, the then EO recorded the statements of the duty LP train number 18409 UP EXHWH Howrah and KSGP, who has stated that during passing of Santragachi at 9:31 hours, and after that at about 9:32 hours, he saw an unknown male person body lying outside.
It is page 16.
Now page 16, man.
Yes.
Statements of loco pilot of train number 38313.
Yes.
During inquiry, I recorded the statements of CSC De, motorman Tikiapara, in which he stated that no any incident occurred in between SRC Maurigram section, and also no any information regarding fallen down of any passenger has been received from any corner. Copy enclosed. Statement of train guard. During inquiry, I recorded the statements of Shubroto Pal, train guard SRC, in which stated that no ACP occurred between Maurigram section, nor the incident took place between SRC. Bank account number verification, etc. Then you collected the verification certificate of the bank accounts number SBI. Extract of message book, collection from form number 2 during inquiry. Statement of the OP Choube. Statement of OP Choube. During inquiry, the then EO recorded the statements of Sri OP Choube, then SIRPF SRC post, in which he stated that on 9/4/2000 he, along with Constable Rajiv Ranjan, attended the PO at kilometer such and such near up line at 21:15 hours after receiving message from the duty TA staff sheet at 20:50 hours at about lying a dead body male on the said place. He, along with Constable Rajiv Ranjan, saw a dead male body on the said road, said place, and after arrival of ASI GRP SRC Sri L Choube with staff at 20:40 hours observed that the dead body of the on the spot. During inquesting the dead body by Sri L Choube, IO, PAN card and IO Aadhaar card, namely Baptu Pal, SO Tapan Pal, Jabgram, Mangalkot district, Bardhaman, West Bengal, were found, and no any railway ticket was found. The dead body was removed at hours after inquesting. After inquesting, and UD case number such and such was registered by CRP. In this regard, the contest SRC and essence were dated such and such. And final report. During inquiry, I observed inquest, PM, and final report of GRP SRC, in which mentioned that at the time of seizing, the seized articles were photocopies of voter card, VID number such and such, Aadhaar card number such and such, in the name of Baptu Pal, and one original local railway ticket, VID number such and such, at UTS number such and such, from Dashnagar to Andul railway station, DOJ, on 9/4/2019, and value of ticket was ₹5 only. And these articles were seized before two witnesses, namely Pintu Pal, Samoresh Pal, on the place beside the railway track at kilometer post number 9/13 to 9/15, up line, and in PM Chalan number 1175. It is mentioned that dead body was sent on 22.45 hours to our Howrah Sodor Hospital through by van rickshaw, and Dome's distance from the place of postmortem is approximately 10 km. At last, in the final report, EO GRPS Choube expressed his opinion that he was agreed to the witness's opinion, but for ascertain the actual cause of death, date and time. Now, statement of claimant, my lord. During inquiry, that the EO recorded the statement of the claimant Anamika Haldar Pal, in which she has stated that on 8/4/2000, husband Baptu Pal left for Satragachi on his private company mart work, and nobody was with him during journey. She also stated that on 9/1/2019, she knew nothing about the husband's death, and her brother-in-law Pintu Pal was informed about Baptu Pal's dead body at the night time by the railway police. On 10/4, next page, my lord, page 17. On 10/4/19, she knew about her husband's death by railway accident from the grandfather of her mobile phone, because Pintu Pal informed the claimants Anamika Haldar's house family members at 5 hours early in the morning that Baptu Pal had died in a railway accident. Pintu Pal asked for only the signature of the claimant and his mother Srimati Supriya Pal over mobile phone. On the same date, as per convincing by GRP SRC, the claimant has already cleared that she knew nothing about her husband's death on 9/4/2019, and afterward she would know that Pintu Pal's brother-in-law claimant was identified by showing Baptupal's dead body in GRP SRC and was convinced to claim against railway for getting claim compensation for the alleged death of Baptupal. And on the basis of GRP, the advocates convincing the claimants sent her and her family members' signature to GRP SRC. The claimant Anamika Haldar Pal has also declared that the Pintu Pal was fully convinced by GRP SRC how to apply against the railway for getting claim compensation for the alleged death of Baptupal, and also called for an advocate for the purpose. That is why Pintu Pal had told her to send signature on a blank paper of Chhatragachi. At last she stated that she had not claimed against railway, but also claim is done on the base of convincing by the advocates of Railway Police Chhatragachi. Now, statement of Pintu Pal. During inquiry, I recorded the statements of Pintu Pal, Clement's brother-in-law, in which he stated on 9/9/4/2019, he and his elder brother, Baptu Pal, with one friend, Samoresh Pal, went to Dasnagar from Chhatragachi at about 5 p.m. to meet their colleague. Thereafter, at about 7:30 p.m., all of them left Dasnagar railway station to Andul by purchasing railway ticket and boarded local train. Due to having rushed, Pintu Pal and Samoresh Pal entered into the coach of the local train together, and they saw Baptu Pal standing on the door in the same running train. When the train was to arrive at Maurigram railway station, then some passengers shouted on the falling of somebody near LC gate number 12 from the train, and they
both got down.
They both got down from the train at Maurigram, where they searched and called Baptupal, and Baptupal not found inside the train and on Maurigram platform. And also immediately they attended LC gate number 12, and Pintu Pal saw his elder brother's dead body lying near LC gate number 12 and identified where he arrived. When he arrived, GRP SI office ASI GRP Sri Choube informed him that a voter card and a railway ticket found from the possession of the dead body, and also convinced how to get monetary benefit from railway administration for the alleged death of Baptupal. Conclusion: during inquiry, it is concluded that part daily diary and statement RPF office, RPF post such and such, no any railway ticket was found from the deceased the spot, but GRP SRC has mentioned one railway ticket white number such and such DSNR in the investigation report, and seized and seizure list. Seems that GRP SRC has shown railway ticket later on during the inquiry to the benefit the claimant. There is no evidence found that the deceased was fallen down from the train. The deceased person himself is responsible for unfortunate death. He is not responsible for unfortunate death of the alleged Baptupal. Report is being submitted for your. So, my lord, this report was totally, my lord, partial report, my lord. This report is not impartial, my lord. This is not impartial. It is in favor of the railway, and why they have produced such a report that is better known to them, my lord. Now, my lord, regarding this, my lord, I would like to argue, my lord, that this is a social welfare legislation, my lord.
Let us see the conclusion of the tribunal.
Oh, sorry. What tribunal has said, my lord? Page number 86, my lord.
Yeah.
86 is a judgment. And my lord, concluding parties. It starts from page number 103. 103, point number 7.9. 103, my lord, please.
103.
103.
Yes.
Hence, no conclusive evidence of bona fide of the deceased is proved to have been recovered from the body of the deceased at the place of occurrence. The court will always give due cognizance to the best available evidence Honorable High Court of Andhra Pradesh has held in case of CMA 947 of 2008, JT Naga Lakshmi Parvati and others versus Union of India, that from section 101 of Indian Evidence Act 1872, it is clear that the applicants having come to the court asserting some facts must prove that the death of the deceased had taken place is an untoward incident, and that the death occurred while the deceased was traveling in a train carrying passengers as a passenger with valid ticket. Therefore, having asserted that the deceased died in the untoward incident and he was having a valid ticket at the time of the death, the initial burden lies on the applicant to establish the same. The initial burden of the applicants never shifted unless respondents admits that the assertions made by these applicants, such evidence is lacking in this case. Therefore, it is clear that the applicant could not adduce cogent evidence to prove that the deceased was having a valid ticket and death of the deceased was due to fall from the train. This 7.11. This is the conclusion. Now, my lord, considering the factual elements coming out from the discussion, these issues are held against the applicant by holding that it is amply proved that the applicants could not establish that he was a bona fide passenger, and the applicant could not also prove that the death of the deceased was caused due to fall from the train. Hence, it cannot be stated that the untoward incident as defined under section 123C(2) of the Railways Act 1989 involving the victim. And thereafter, my lord, the case was dismissed. So, my lord, my humble submission before your lordship is that my lord, it is a social welfare legislation, and my lord, main aim is that to provide assistance so that they can sustain, the family member can sustain even after demise of their own sole earning member. Now, my lord, here it is a civil in nature case, my lord. So, preponderance of probability, this principle is applicable, and I am showing judgment also. The principle applicable for adjudication of this case is, my lord, principle is preponderance of probability, and there is no scope of using the principle of beyond reasonable doubt in this case. Now, my lord, here several documents are there to show that GRP seized the railway ticket and the ticket was recovered from the pocket of the person concerned, and my lord, though there is contradictory statement by the railway authority itself, in order to avoid their responsibility, in order to avoid their liability, they have made this, my lord. Otherwise, it is amply clear, my lord, that he was traveling as a passenger of the train, and it is absolutely an untoward incident. He fell down from a running train, and my lord, it is not a self-inflicted injury, my lord. It is not a self-inflicted injury, and my lord, thing is that, my lord, another thing is that, in Prabhakaran Vijay Kumar case, man, Rina Devi case, well, it is stated, my lord, death of the victim cannot be termed as self-inflicted injury. In case of death, if death happened, it cannot be termed as self-inflicted injury. And my lord, here I am placing before your lordship one judgment, my lord, Rajni, pronounced by Honorable Supreme Court of India in 2020.
Anyway, give those judgments.
Rajni and others.
You don't have to read it out.
Relevant judgment also. Relevant paragraph also. 2025 SCC online. SC 2182. 2182. Here, my lord, in para number 9. Para 9, 11, 13 and 14. Para 9, 11, 13 and 14. These are the important paragraphs. Nine. The legal position, 9, my lord.
Yes.
The legal position is not in dispute. Section 124A of the Railway Act 1989 embodies no fault regime for untoward incident, but compensation remains predicted on the victim being a passenger for present purpose. Explanation 1, 2 to section 124A would be relevant in the background of the same having been denied by the railway authority. It reads as follows. Explain. Passenger includes a passenger who has purchased a valid ticket for traveling by a train carrying passengers on any day or a valid platform ticket and becomes a victim of an untoward incident. In Union of India versus Reena Devi, the court affirmed that the compensation under section 124A is payable whether or not there has been wrongful act, neglect.
Para 16.
Para 9.
Para 9.
Para 9
Yes.
is written in after the bold letters, after the sentence written in the bold letters. In Union of India versus Reena Devi, this court affirmed that the compensation under section 124A is payable whether or not there has been wrongful act, neglect or fault, and clarified two facts, namely the regime is one of strict no fault liability with the exception confined to the proviso to section 124A, and two, mere non-recovery of a ticket from the victim persons is not ipso facto fatal, where the claimant lays a credible prima facie foundation upon which the onus may shift to the railways. The central inquiry, therefore, is whether the appellants had first discharged the threshold burden of proving the fact that the deceased was a bona fide passenger of the train number such and such, so as to trigger any shifting of onus on the railway authority. And my lord, para 11, huh? Para 11.
Yes.
This court, in this case of Dolly Rani Shah and Union of India, has held that the burden of proof would shift to the railway once the claimant appellant filed an affidavit stating the facts and averting to the report arising out from the investigation conducted by the railway authority. It has been further held from the recapitulation of the various judicial pronouncements leading to the present appeal, it can be said that the primary issue is whether the deceased was travelling on the train in question. In Reena Devi, Union of India versus Reena Devi, a two judges bench of this court considered the question of the party on which the burden of proof will lie in cases where the body of the deceased is found on railway premises. This court held that the initial burden would be on the claimant, which could be discharged by filing an affidavit of the relevant facts. Once the claimant did so, the burden would be then shifted to the railways. Significantly, it also held that the mere absence of a ticket would not negate a claim from the deceased was a bona fide passenger. Claim that the deceased was a bona fide passenger. The relevant extract from the ruling of the court is reproduced below. We thus hold that mere presence of a body on the railway premises will not be conclusive to hold.
Yes, that is there. Discussed.
Yes. And my lord, next para is para 13.
Yes.
Para 13. In 13 and 14. In the light of the above, we are considered view that the High Court has faulted in affirming the finding of the Railway Claims Tribunal, whereunder the claimant's petition had been rejected for non-production of Caesar memo of the ticket and for non-examination of the investigating officer, which is and was main thrust of the argument canvassed by the learned counsel appearing for the railways. This reasoning ignores the consistent judicial line that the absence of formal Caesar or witness examination does not by itself negate bona fide travel when other material evidence substantiate the claim. Mere technical irregularities or lapse in production should not defeat a legitimate claim under a welfare statute like Railway Act 1989, particularly Chapter 13, which deals with the liability of the railway administration for death and injury to passengers due to accident. Hyper-technical approach which would frustrate the object of providing relief to victims of railway accident should be eschewed. The instance of a formal Caesar memo would amount to importing standard of proof which normally is sought for a criminal trial. Hence, we reaffirm that proceedings under Section 124A of the Railways Act are not criminal trials demanding proof beyond reasonable doubt. but welfare statutes are governed by the principle of preponderance of probabilities. Once the foundational facts of one, possession of issuance of a valid ticket, and two, occurrence of an accidental fall from the train are established through credible materials, this statutory presumption of bona fide travel must operate in favor of the claimant. The railways is an instrumentality of the state cannot defeat such claims by pointing to procedural imperfections in investigation of non-examination of formal witnesses. To hold otherwise would erode the beneficial character of the legislation and convert a social justice remedy into a forensic obstacle race. So, my lord, here means, my lord, Honorable Supreme Court is of a clear view that, my lord, if the ticket is recovered, my lord, and, my lord, if it is found that he was really traveling back as a bona fide passenger, then, my lord, he is entitled to get compensation. So, my humble submission before.
So, apart from this, any other decision? Rina Devi
judgment has been discussed in this particular case. Rina Devi and, my lord, another judgment, Dolly Rani Shah, and Rina Devi, Dolly Rani Shah, and Prabhakaran Vijay Kumar. All the judgments are discussed in this single judgment, my lord. An important paragraph is paragraph number 14, my lord. 9, 11, paragraph 13, 14.
That's all?
That's all, my lord. My humble submission is that, my lord, the award passed, the dismissal order passed by the learned tribunal is liable to be set aside, man.
Yes.
Judgment copy never.
My third submission, my learned friend stated everything here. But only one submission was here. The factual score, the Pintupal is the key witness, man. The Pintupal, the elder brother of the deceased. He stated in his deposition, my lord, that he was in his friend's house, and thereafter he meet the elder brother. The ticket was purchased at 15:47 hours, and he stated he was in their friend house at 7:30. That's the one key question, man. That no eyewitness was there, whether the accident had happened or not.
Yes, where is the statement of Pintupal you are relying?
That's the only key witness, my lord, the Pintupal. There is a discrepancies.
That he was in his friend's house.
He was in friend house.
This is Pintupal.
Pintupal. At 7:30. And so, my lord, at the time of incident, Pintupal stated that he was traveling with his
victim,
elder brother, elder brother. But train had not stopped by pulling chain. He said he get down from Morigram station and pick up a Toto and went to the place of occurrence. But the court witness number one, my lord, loco pilot, he has firstly saw the incident that one unidentified body was lying in Satragachi station, and then he informed to the station master. The statement only, my lord, is a beneficial piece of legislation. The Rina Devi judgment already covered by it, but the section 229 clearly indicates who is the passenger. What is the status of this passenger? Section 229, my lord. That at the place of occurrence, no ticket was found. At the place of occurrence. It is a statement of the visiting officers. 70. Page 70 at last paragraph.
Yeah, আমার তো marking করা আছে। On the date of incident, I page 71. Last paragraph.
Yes.
On the date of the incident, I went to Dasnagar to see my allying friend Souvik Mondo.
Page 70.
70, madam.
Yes.
70.
Yes.
Last. From the bottom, my 8, my God. 8 line. On the date of incident, I went to Dasnagar to see my allying friend Souvik Mondol from Dasnagar. I purchased my ticket. My deceased brother came to Dasnagar station at 17:47 hours. We boarded the train at 18:10 hours. I did not see my brother falling down from the train. I did not pull the alarm chain. After the incident, I departed at Morigram at 18:24 hours. Then by a Toto, I reached the place of occurrence with 20 minutes by 18:45 or so. Samaresh Pal also went to the spot with me. I do not know whether the GRPS called an advocate in the GRPS. It is correct that I was told by the GRP that in case we do not file any claim application, we will not get any compensation. It is correct that the signature of my sister-in-law was taken by the GRP for filing this claim case. It is incorrect that on my behalf, my sister-in-law is signed on blank GRP paper. It is correct that I did not inform the incident to my sister-in-law till the next morning. It is incorrect that my sister-in-law was suspecting me for the death of my brother. It is incorrect that I told my sister-in-law that in case I do not adduce evidence, she will not get any claim. It is incorrect that I was advised by an advocate of the GRP to become an eyewitness in this case as a co-passenger. I only got the Aadhaar card, PAN card and voter card of my deceased brother, nothing else. I do not remember whether any receipt was taken from me by the GRP while giving this article. My deceased brother was not carrying any money. He was also engaged in a welding job. He was married. It is correct that he was going to buy clothes from Andul, though he was not carrying any money. Self-stated that he was to bear the cost of the garments to be purchased by his brother. I signed the inquest report and seizure list in the GRP Satrageji. I did not sign the inquest and seizure at the spot. My statement was recorded in the inquest report by the GRP. I do not know English. I cannot say what was written in the inquest report. I signed the inquest report and seizure list in the night of the very date of the incident.
Anyway, police authority also did not seize any money from this person.
But only the time. Only the key witness is Pintu Balman. Application witness number 1. He has made a deposition, but she was not an eyewitness. Only the key witness is somebody. Pintu Pal. And other witness, co-witness was Samaresh Pal. Court has given liberty to produce evidence, but they did not produce this evidence. That Samaresh Pal. Only the timings, my lord. He was Pintu Pal was in the house of his friend Souvik Mondol up to 7:30 p.m.
Where it is stated? Where it is stated?
বলছে কিন্তু ছিল So, my lord, this is the key part, your lordship kindly look. This the key with
So
the
time is inconsistent according to you.
all the time. It's what discrepancy is there, and no documentary proof is there by the Pinto that he has any ticket or any evidence that he was in the train traveling with the disease. That has not been given.
He signed the inquest report. my lord. And page number 67, if your lordship kindly come. Page 67 টা দেখুন, page 67. Page 67 is the cross examination of PW1 claimant.
Yes, no documents by Pinto Pal.
Yes. But his statement cannot be discarded. my lord. And my lord, if your lordship kindly come to page number 67, your lordship.
Yes, let
My lord, I have no objection regarding application witness number 1, that is disease wife. That she was not an eyewitness. She was not an eyewitness. She was informed after 24 hours at least.
Yes, sir.
The accident happened on 9th April 2000. 9th April, my lord. And she was informed on 10th April in the morning
That is
by the
corroborated.
Pinto Pal.
That is corroborated by Pinto Pal also. Pinto Pal said he didn't inform this matter to the sister in law.
So her witness gone. Hearsay will come.
বেশি বলুন।
Yes.
This is only my submission, your lordship, to kindly go through the evidence, and there is a key witness.
Yes.
Only the discrepancies is there. How far it is possible she was, if he was along with the deceased person.
So how far the evidence of Pinto Pal is to be relied? Yes, record an order.
But one reply, my lord.
Yes.
Pinto Pal himself has stated in his evidence that it was overcrowded. He entered inside, and this person was standing
On the gate.
Beside the gate.
Well, it is the common sense, my lord. If person was fallen down from the stairs, there will be some roaring between the passenger.
And my lord, yes, the passenger just shouted. And then
Yes, record an order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 19/8/2026.
Bye.
Bye.
In this matter, I am appearing on behalf of the respondents claimants.
Item 6.
5 and 6. In this matter, your lordship heard this matter from the appellant, my lord.
Have you come with your written notes?
And last occasion, my lord, learned friend took time to submit on my cross appeal, my lord. My cross appeal. Lord, let me, I have not yet heard, only 5 minutes.
No.
So, your lordship, kindly allow me 5
You have
minutes.
submitted your written notes.
I have already submitted on 2 occasions, my lord. On 2 occasions, in details.
No, in your written notes, have you annexed this?
Yes, I have annexed the realized judgment, my lord.
So there is counter objection also.
Yes.
No, only so far I have made out my case. He has filed his opposition, and he also has making a submission on in favor of his cross objection. In cross objection, one point he has raised: the mother of the deceased should be considered as a dependent and family member, and for that number dependent should be 4. And relying upon a
One third. How much was deducted? 1/3.
1/3 considered by the learned tribunal.
You see, if it is unmarried, then half, 50%.
No, it is not married. Married, wife, son. আমি কিছুই বলিনি, তুমি 2.5 ঘন্টা ধরে বলেছো।
No.
বলো, আমি বলবো সব।
just এইটুকু পাঠ তো আজ তো কিছু তোমার
No. 1/3 deduction means
petitioner was
wife and 2 child. Original petitioner. And the mother was not never made as a petitioner, he was made a opposite party number 1. So only now he is claiming the contribution of the mother. During the pendency of the case, mother died.
Now the question is, the claimants are what? Children and
Children and wife.
husband. Oh, wife. So if that is so,
Yes.
then 1/3.
And now he is claiming 1/4, including the mother. That's and relied upon decision of Kitty versus Oriental Resource Company.
I have already read that judgment.
Yes. To contradict that decision, in that decision, the mother was the petitioner. Until unless the petitioner here in the instant case.
Pro forma respondent.
Yes, you have the performance. Now, that's why I'm trying to, in the, if you will assist kindly, the claim petition also, my wife, I mentioned in my written notes of argument that she was never was the petitioner. She declined to join with them. This is the evidence of the PW1 of the wife. She declined with them as a petitioner. So he was made party opposite party number 1. So as a opposite party number 1, he cannot now claim during lifetime he took no responsibility of his mother-in-law. Now he is claiming the contribution of the mother-in-law. That was not decision. So that decision is not applicable, and that should be. So the claim towards the mother should be discarded.
No.
That part.
The victim is what? The victim
claiming that he was a helper.
Okay, now the victim is survived by the 2 children, the wife
and mother.
Mother is made pro forma opposite party.
Yes.
Pro forma opposite party means she did not join the claim application.
Yes.
But she has been.
She declined. Not only joined, she declined. This is the evidence of the PW1.
Evidence to dekha.
So
that is why the tribunal considered 1/3.
1/3.
Yes. You have prayed for enhancement also.
In cross objection.
So why was the mother not made claimant?
When the son, that is the deceased in this case, my lord, died, at that time of my lord, 4 survivors were there. Wife, 2 sons, mother. My lord, what happened? Your lordship knows the topography of in our society. My lord, after death, my lord, the family disputes arose, my lord. That is why, my lord, the wife and 2 sons, my lord, filed claim application, claiming, my lord, the pro forma respondent as her mother, or his mother. My lord, your lordship kindly come to page 4. Page 4, serial number 19.
Serial number 19, yes.
Serial number 19, my lord, small one, my lord, Srimati Deepa Singh, thereafter minor Rajesh Singh, thereafter minor Rajdeep Singh, thereafter, my lord, 19A. 19A.
Yes.
Srimati
So this was brought by way of amendment.
No. From the very threshold of the claim application, my lord, she was there. It is not amended, my lord. Since, my lord, the tussle between wife and mother, my lord, that is why, my lord, she made pro forma respondent. That's, my lord, normally done in all cases in the tribunal. My lord, thereafter, my
the
lord,
appellant in the instant case challenged the matter on merits as well as the quantum.
Yes.
Both on merits as well as the quantum.
I, my lord, filed one cross objection, my lord, challenging, my lord, non-granting of rupees in full claim, my lord. The claim was 9,000 plus 1,000 at tiffin allowance, 300 rupees per day, 300 into 30, 9,000 rupees, 1,000, total 10,000. Learned tribunal granted only rupees 6,000. And, my lord, the age, my lord, 48 years, my lord, learned tribunal accepted that, and multiplier applied 13. Okay, my lord. Dependents, my lord, wife, son, 2 sons, mother. my lord, 4 persons, my lord, as per claim. My lord, what happened, my lord? That is the problem. What happened, my lord? During trial, the mother expired. So her name expunged. That is the evidence of the Deepa Singh.
No, name expunged and the years became this.
Yes, my
All
lord.
these three.
Name has been expunged.
The
deleted
years,
from the-
years are already on record.
already on record. So, initial, my lord, when the deceased was alive, my lord, the 4 persons were dependent on her on his income. না 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 আমাকে বলতে দাও শেষ করে দিই তুমি তো আমাকে বলতেই দাও নি ম্যাটার তুমি একাই 3 ঘন্টা ধরে বলেছো তুমি বলোনি না আমি কিছুই বলিনি আমাকে বলছিস বলে তুমি কিছু বলছো না সব রেকর্ড আছে ভিডিওতে রেকর্ড তো তোমারই আছে my lord that is the problem. The mother was initially, my lord, in the claim application, but subsequently during trial, my lord, when the evidence was taken, my lord, just before that mother expired. So her name was deleted from the list.
Years being on the record.
My lord, actually, my lord, the other 3 claimants are on record, my lord. That 3 claimants are still continuing the case, my lord, till that date. So Supreme Court, my lord, what said, my lord, in my lord, in Kirti, my lord, I have, my lord, annexed in my written notes of argument. Your lordships kindly come, para 9 and 10 in Kirti's judgment. So, at the time when the claim case was filed, or at the time of death, how many persons were dependent on the income of the deceased, that has to be considered. That is the cause of action.
Okay, so your ground of challenge is this
So it should be one
deduction and the monthly income.
Monthly income and, my lord, future prospect. Future
Prospect not awarded.
Not awarded, my lord. 25% should be in view of the age. And
So
my
nothing
lord,
is awarded on account of future
no
prospect.
future prospect awarded in this case. And, my lord, my friend, my lord, learned friend, my lord, challenging the general damages, my lord, which was in exorbitant in his claim, my lord, in as per his claim, my lord, your lordship will consider the parental and filial consortium, my lord, in that respect. And interest, my lord, awarded 6.5% per annum from date of filing claim till the date of payment. My lord, nowhere it is written in our statute book or by the any court of law that 6% is fixed.
No, how much interest is awarded?
6.5%.
6 point. Anyway, that can be considered.
Right. My lord, this all, my lord, and my lord, what, my lord, I have missed in my written notes of argument in 2 arguments, one supplementary and first, my lord. My lord, owner appeared in this matter and filed written statement. Owner appeared. My lord,
Thereafter
owner,
did not contest.
but did not contest at the latter stage. My lord, your lordships kindly come to page 13 of my paper book. That is, my lord, the owner's written statement. Page 13. Page 13. On 3.
Yes.
Yes. My lord, the owner came and filed this written statement. Your lordships kindly come to the bottom of this page, my lord, serial number 6, paragraph number 6.
Yes.
That the contents of column 2, 3, 7, 8, 9, 10, 11, 12, 13, and 14, the application are the mere statement of the petitioners and they are called upon to stick to thereof. My lord, I have, my lord, read the rest of the portions, my lord. I could not find any paragraph challenging the claim applications para number 4, 5, and 6. My lord, what is, my lord, 4, 5, and 6? Page 1 of the paper 2. It is our case that he was the khalasi of the vehicle in question, and 4 is occupation of the person deceased, khalasi of Tata 407, truck number such and such.
With party number, allegations are incorrect.
Yes. And 5, my lord, name and address of the employer, my lord, the Gautam Sarkar, he himself, my lord, filed the written statement. as owner. And 6, my lord, the monthly income rupees 300 per day plus tiffin allowance, that is rupees 10,000 per month. All 3 points, my lord, they have not challenged in specific.
That is para number 5.
Para number 6. Para number 6, 2, 3, 7, 8, 9, 10. 4, 5, 6, they omitted intentionally. They are not
5, 6 was with regard to
4, 5, 6 of the claim application. 4, 5, my lord, 6, that is my occupation of the person, name and address of the employer, and my monthly income of the person.
4, 5 and 6.
Yes. That was not challenged by the employer, come owner of the vehicle, who has been figured in this claim application as OP number 1.
And this victim was employed
Khalasi of the truck of such and
the
such.
truck.
And my lord, the insurance company appeared and filed written statement. My lord, a big written statement starting from page 8, 9, 10, 11, 12 of the paper book. But I could not find anything regarding their appeal's main ground, that the Khalasi has not been covered by the policy issued by the insurance company to the insured, that is the owner of the vehicle. I could not find any ground. My lord, kindly consider, I have taken this point in my written notes of argument, that the insurance company subsequently also not filed any additional written statement. The learned tribunal also not considered this point because that point was not there at the time in the claim application, and the written statements are not covering those. So learned tribunal framed issues and not on that point. The trial continued, no challenge. Even my lord, I have some doubt, my lord, even in, they have not taken in argument stage, though not permitted them. I have taken in length, my lord, in my petitions, in my written notes of argument. 2 written notes of argument I have submitted here.
That's all.
My lord.
But I have already taken the points, mentioned it. Main grounds is the insurance part was relied upon. The insurance does not cover the policy of a third party, only third party. And the Khalasi, he was not a third party at all. And it is a pure question of law when it is not a case that whenever there is a policy, everybody will be covered by the policy. He must be a third party. Supreme Court already, I have relied upon decision. Supreme Court category held Khalasi is not a third party. Neither, and so for the employment, he is not, the owner did not admit it, that he is my owner. And so for the other points, not so before the mother should be here. In that said decision also, mother was a petitioner, but in the instant case, he was not a petitioner. Not, and also it was a categorically deposed that he was not willing to add in the as a petitioner in the along with the present claimants. And so for the employment 6,000, there is no evidence, documentary evidence. In repeatedly case, I have also relied on some decisions that if you want to argue that I am an employee, then you have to prove by documentary evidence. Employer-employee relation should be established by documentary evidence. He has not put no documentary evidence, neither no one has. And rash and negligence, so far the rash and negligence is was not the only person he was, as an eyewitness has come, he followed the vehicles from behind. Now, what happened in front of the vehicle, no other vehicle was involved. The same vehicle, or so how he can establish that there is a rashness of the driver of the concerned vehicle. Rash and negligence was not also proved. This is since it is a first appeal, so we've got 4 or 5 cases, says 173 73 appeal akin to the first appeal. All the points can be revisited by the first appellate court, and it should be revisited. That was the decision of Honorable Appellate Court.
I have covered that point, madam, in my written notes of argument. And this is not workman's compensation.
Anyway, next.
So relationship is not material here. To
মাঝখানে যে
establish.
কথা বলবো না।
মাঝখানে কত কথা বলছি?
Anyway, please.
বলিন তো, তুমি তো আগে কথা বলেছো। And so far this is very important. What is the position of the victim? He claimed that he was a Khalasi. There is independent evidence of independency. In the charge sheet, police, after investigation, mentioned him as a messenger or passenger. So he cannot be claimed as an employee, even after investigation by neutral body, police authority. Now, he has relied upon this charge sheet. The one part of the charge sheet is relying upon for establishing the accident and involvement of the car. Then other part of the evidence that cannot be discarded, that is the decision of Honorable Supreme Court. If he has relied upon that charge sheet, so it is his document. In the document is proved that he was a passenger, so he cannot claim that I was a Khalasi. On the one hand, he will rely upon the decision. So I relied on Premlata Shukla. It is particular if one party relied upon the if it is.
Anyway, you have dealt it in your written notes. You have annexed this document in your written notes.
And so far the interest of penal interest also given, that is beyond the jurisdiction.
Anyway, that can be considered.
And so far the usual Supreme Court laid down the usual rate for fixed deposit for 1 year. And so that's why for 6% is given in a usual cases. And so far I have also challenged the quantum on the ground of Pranay Shetty overruling the Pranay Shetty cases. Then there was a general damage. It was excess. That was also. This is a nutshell. This is okay.
ঠিক আছে।
Yes, anything else? You have covered the decisions in your arguments. Yes, record and order. Learned advocates for the parties are present. Heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 14/8/2026.
14. Okay. এটা কি তুমি দিয়েছো? এইটা নিয়ে নাও। এইটা উনি এটা ফাইলে যাবে। ওনার যে নোটসটা উনি দিলেন।
Yes, written notes of arguments file be kept with the record.
তুমি আমারগুলো সব এসে পড়ে গেছে। তুমি এবার নিজে বানিয়েছো। তুমি আমাকে হ্যাঁ কপি দাও। কপি তো দিইনি। করবো কি করে? তুমি এই কি বলতে কি নামটা কি? 14th August.
Very much complete. Yes.
আমাদেরটা দিয়ে দিই।
এই